Hey guys, happy Independence Day. So this is going to be more of a casual discussion type stream. Obviously, 4th of July, you think of fireworks, think of freedom. Doesn't matter if you live in the United States or not. Today, we're going to be talking about innocence and wrongful convictions, because that's kind of what I think of when I think of Independence Day. So that can be something anyone can relate to, no matter where you are in the world. Shout out to Amanda getting here early. And we also have Mrs. Cash Money Cass. So big congratulations to Cass on her wedding. She looked absolutely amazing. So drop some slime champagne glasses in the chat for Cass. And guys, what we're going to talk about today, I should give a forewarning. We are going to be dealing with bad expert witness testimony. We're going to be dealing with what I'm characterizing as malicious prosecution, probably maybe just overcharging. That's debatable. But some of the accusations we're going to read about, although the accused may now be exonerated of the accusations, are still really heinous accusations. It will involve children. It's not, I don't like to cover live trial streams that are about something terrible happening to a child. But we're in the post-conviction space here. So we're going to be talking about things that maybe I just wanted to give you guys the warning ahead of time, since you might not expect it on this channel. But really, we're mostly going to focus on the story of Jimmie Duncan. And the reason he's in the news, he was recently exonerated. A judge, the court found him factually innocent. The prosecution is appealing the Supreme Court decision, the Mississippi Supreme Court decision. And the family members of the victim are speaking out and saying, well, the prosecution isn't even consulting with us. And we think they railroaded this man. And we don't want the prosecution to pursue an appeal so they can retry this man. So that's why this is making news today or yesterday, this week. But this case stems back. This is like decades and decades that this family and this wrongfully convicted man have been dealing with this story. As we go through this, the articles we're going to look at are going to loop in other stories of wrongful convictions in Mississippi, and I think we get into some in Texas. And the common denominator, expert witnesses that are now completely discredited. So we have Michael West and Stephen Jane. Those might be some familiar names to you guys. We're also going to look at this study from Reason about expert testimony gone horribly wrong. And it's going to dive into some of the witnesses we're going to talk about here. If CH Rich makes it over to the chat, big thank you, because he's the one that sent over the Reason article after I'd shared this Mississippi story over on X. So it's going to be a lot. Again, I hope everyone's having a good day. I mean, these are heavy topics to talk about, but they're important to talk about. And I think it's really interesting that we're coming from a story where the victim's family is advocating for the accused. And I think that's just an incredible thing to see. So, hey, Trakisha, good to see you. Destined to be, good to see you. Yes, Zach Carter says, hey, little Woody got arrested. Yep, so Happily Angry Lawyer did a stream on that. Let me link to that real quick. And it went into a whole bunch of other crazy stuff going on in Fulton County, a lot of stuff that I've never seen discussed on YouTube before. So it's not just the Woody story. But speaking of Fulton County, another good area of focus, if you want to look at prosecutions with expert witness testimony and things that could unfairly take away someone's freedom. All right, so I'm going to call this the Fulton stream from Happily Angry Lawyer. If you go to his page, it's the one with the thumbnail is just a big lime green signal. So, and all the congrats here to Cash Money Cass. That's right. Thank you guys so much for celebrating. Don't forget we have the slime champagne glasses. And hey, Biff. Hey to Shanita, and hey to Brooklyn. So let's get the backstory here. This is still early on in the stream, so I have to use some censoring language here. But the backstory, we have mother calls for man exonerated of raping and murdering her child to go free. wrongful convictions by 2 discredited Mississippi experts, tops at least 10. So this means more than 10 have already been overturned, but there could be more. A victim's family in Louisiana is now speaking out. So this is Jimmie Duncan here. This is his half sister, Nicole Duncan. So obviously, in a situation like this, Nicole is impacted. Jimmie Duncan's obviously impacted. He's the one that was convicted and wrongfully incarcerated. And let's see what happened. So prosecutors are fighting the release of death row inmate Jimmie Duncan after a judge found him, quote, factually innocent of raping and murdering 23-year-old Haley Olivo, are not speaking for Haley's family, her mother says. Speaking publicly for the first time, Allison Leighton Statham called for Duncan to go free in a July 22nd bail hearing. I think this might be July 2nd, or maybe June 22nd. This innocent man is on death row, she told Mississippi Today. Justice needs to be done. So back in April, a judge threw out Duncan's conviction, questioning their conclusions and citing the failures of his court-appointed counsel. And it's always, sometimes when we get these ineffective assistance of counsel claims, there was a mistake done by somebody else at trial. But because trial counsel didn't object and preserve the record or fight it at the time, an appeals court might say, hey, it wasn't preserved, so really you need to bring this under an IEC, an ineffective assistance of counsel claim. So sometimes when we see that a judge found, yeah, there was ineffective assistance of counsel, that still means that somebody else was doing something wrong, and trial counsel probably just failed to call it out at the time. So, but I always hate that because it always just makes it seem like the attorney did something wrong, but the prosecutor, the detectives, wasn't them. But that's not just the case. So prosecutors have appealed the judge's decision and are fighting his release on bail, saying Duncan poses both a flight risk and a safety risk to not only the victim's family, but also the general public. Now, again, victim's family could be more than just the mom that's speaking out, but it's interesting to hear that they're not speaking to the family, yet they're speaking for the family. Statham disagreed, that's a family member, and said she wants all of the evidence, including a sealed video of a bite mark expert examining her child's body, made available so that everyone can know the truth. Authorities are still wanting to bury the truth, she said. What they did was railroad him. This is the victim's mom saying this. For a long time, Haley's paternal aunt, Jennifer Berry, awaited word of Duncan's execution, she said. We've mourned quite a few people in our family, and we have never mourned like we mourned when that child died. So this is the paternal aunt. This is Jennifer Berry. And it says she was awaiting word on the execution, but since digging into the case, she now believes that he should go free. So she's already saying, we've never mourned the loss of somebody like we've mourned the loss of this child. And when we hear what Duncan was accused of doing, you're obviously going to think that that's how your family member tragically passed. And you have to grieve what you believe is how that family member passed. And then decades later, you end up finding out that that's not really happened. And now someone else who was accused of doing something that these things didn't happen. Like, what if this person was executed? What if Jimmie Duncan was executed? Because me personally, I would feel grief for that if I felt like it was unjust. So to me, none of this helps the family members. So since talking with a documentary filmmaker in February and digging into the case, she believes he should go free. I've been in turmoil since realizing this. There you go. He's a young man who was falsely accused of a crime he didn't commit. She has petitioned prosecutors, the attorney general, and the governor for a meeting, but has yet to receive a reply. Ooh, and I think I'm blocking the screen. Sorry, guys. So all of and obviously every office operates differently, but I think of in the YSL trial where we had Love proudly proclaiming to be an advocate for the victims. So it's always interesting to hear, another prosecution office, or when the circumstances are different, because we had it happen with um, Donovan Thomas's mom when those last plea deals were given out in the YSL trial. Donovan Thomas's mom came out and said, "Hey, they didn't even consult with us. They didn't tell us." So it seems like in certain circumstances, we love to consult with victims of the family. We're advocates for them, and then suddenly we cold wall them. We cut them off. We don't want to speak to them. It's like we're hiding our tail between our legs. The judge's dismissal marks at least 10 wrongful convictions involving pathologist Dr. Stephen Hayne. So some of you might be familiar with that name. We're going to hear a lot more about Stephen Hayne if he's new to you. He has since died. So, he got to live his life screwing other people over, and he doesn't even really get too much of his day of shame. Or bite mark expert Michael West, who once claimed he matched a suspect's teeth to a half-eaten bologna sandwich. Now, I don't know about you, but in my life, when I've eaten a bologna sandwich, it's been on like soft, cheap white bread. The kind of bread that like just mushes together the second you look at it. So I'm not really sure that's the type of physical material with the density or physical integrity to really capture a good mold of something. But what do I know? 8 of these wrongful convictions happened in Mississippi. In 1994, the Board of Forensic Odontology suspended West for a year for overstating credentials. Now, this is reminding me a little bit of Mr. Shannon Burgess over in the Karen Reed trial, who really beefed up his CV letter. And misidentifying bite marks. And a dozen years later, he was forced to resign from the American Board of Forensic Pathology. So completely disgraced. In 2008, the state of Mississippi barred Hayne. So this is the other guy. This is Stephen Hayne, from doing autopsies. They barred him from doing autopsies. He once wrote in his autopsy report about removing and examining a victim's ovaries. Chat, what do you think the problem with that is? What do you think they're going to say? So he does something that's fishy after he says he removed a victim's ovaries. What does it say? The problem, the victim was male. So this guy's barred from doing autopsies. Oh, did they link to it? Hold on, there's a link to the case. Oh, it's paywalled. Well, I think we got the gist of why that's a bit problematic. So, oh gosh, you guys, this is who's on the stand putting people's lives just in front of the jury, for the jury to, the jury gets to consider what's put in front of them. They might not necessarily be seeing, oh, hey, this expert witness is telling us this happened here. They might not be hearing, yeah, well, this guy also said he removed a guy's ovaries once. So the jury's kind of isolated from these ridiculous things on the outside, and the crap that they put together, it's tied up with a neat little bow, and they present it the way they want to present it when they're on the stand. The half-eaten bologna sandwich. John says half-eaten bologna sandwich. Potentially criminal, better look out. And Clyde, little guys, potentially criminal's dog's name is Clyde. Better watch out for those little bite marks too. There's a double look out there. Good to see you, John. Mr. Big Play Bray is here. Good to see you. Peter Max, good to see you. Says strange that it is just a judge that finds him innocent and not a jury/fact finder. If it's a bench trial, I would expect both sides to agree to that. So I think this is because it's at the appellate level. So this judge was making a finding of factual innocence through the appeals process. So, but it was a jury trial at the trial level. Yeah. Yep. And Peter also says bite marks are notorious for being suspect. It's not a fingerprint. And not for nothing, but like, I don't know. I feel like, and when you're younger, your teeth kind of can still be shifting around. Like, I had braces a long time ago. This is gross, but my dog, when I was younger, got to my retainer and it was bent out of place and I never got a new one. Like, that was it. No more retainer for me. So my teeth have shifted because there was no retainer, and I think they've stopped shifting now. I don't think they've really shifted much. But people, periodontal disease, your teeth get loose. They move around for that reason. They get chipped, so they leave different impressions. So it's like, even if a bite mark in a close period of time might be similar, I feel like that would change pretty quickly. You can't rely on today's bite mark being tomorrow's bite mark. I don't know. So, but yeah, a whole big problem. It's really a junk science. And it's crazy to think that for decades it was used to win convictions. And Shanita says that was some bullcrap physical evidence, bite marks on sandwich, and the defense should have challenged it. Yep. Yep. So, just crazy. Yeah, I think this is a common thing with the retainer. Like, it's just whatever. Just whatever. It is what it is. Jazzy T, good to see you. Good morning. Good morning. So what else do we have here? That same year, Levon Brooks and Kennedy Brewer were exonerated after spending a combined 30 years in prison. That's like almost my whole life. Wes bite mark testimony helped convict Brooks of the great murder of a 3-year-old girl in Noxubee County. When another 3-year-old girl was raped and killed, Wes gave bite mark testimony that helped lead to a death sentence for Brewer. DNA discovered the truth. A serial killer had raped and murdered both girls. He confessed to his crimes, and Brooks and Brewer were freed. So this guy is just two wrong people. Two totally different individuals were convicted of something that was later tied to a third individual that had done both. So if there were really bites, if there were bites at all on these two victims, either the science doesn't work, well, that would mean the science doesn't work. But there's another question here for me. Were there really even bite marks on these victims? Because we're going to get into a little more on some other issues with West. It remains unknown how many other wrongful convictions these experts may have played a role in. Hayne once said that he conducted, guys, get this number, 30,000 autopsies in Mississippi. West said he has analyzed more than 300 bite marks and investigated more than 5,000 deaths. He no longer believes bite marks should be used in court and did not respond to requests for comment on the dismissal of Duncan's conviction. Yeah, sorry, your little expert run is over there, my guy. Barry felt compelled to come forward now and call for a review of each case in Louisiana and Mississippi involving these discredited experts, she said. Every case they put their fingers on needs to be reopened and examined. So just think about, and not every autopsy necessarily ends up being used in a prosecution, right? But we know, at least just with West's involvement, for some reason he was brought in to analyze bite marks over 300 times. This was probably for a use in a prosecution, and then investigated more than 5,000 deaths. So that's a lot just on West's work to have to go and review. And then we got this big pull quote that says, I wasn't going to lie for them. So it's going to get worse. This is where we get into, it's not just the junk science of experts being relied on by prosecutors that don't know better. This is where we get into what I'm going to characterize as prosecutorial misconduct. On the morning of December 18th, 1993, Statham said as she left for work, Oliva was bouncing on her bed, tossing her moo cow in the air. So, like a toy, you guys. She said she left her daughter in the care of the 25-year-old Duncan, whom she loved and had been living with for several months. Duncan, who has maintained his innocence for more than 3 decades, told police he made Oliva oatmeal for breakfast and put her in the bathtub where the water measured less than 3.5 inches. While doing dishes, he said he heard a noise and found her face down in the water. He said he grabbed her out of the tub and ran next door. The neighbors, paramedics, and doctors were unable to save the life of Oliva, who had suffered recent seizures. Now, I get that we're at a point where maybe we want to say you've got to keep your eye on a baby in water at all times. I'm not a parent myself, but it's just, accidents can happen, right? But still, this would, to me, would not rise to the level, let's say it's negligent homicide. If the prosecutors wanted to pursue negligent homicide for this, we wouldn't have this man on death row. But that's not how they pursued this case, right? So maybe this was an accident that could have been prevented by Duncan himself, but the outcome we have doesn't match that circumstance. When Statham said she arrived at the emergency room, Duncan was distraught, apologizing over and over. Police charged Duncan with negligent homicide, right? So we're here. That kind of maths a little bit, right? Figure it out, maybe. At the hospital, when West Monroe Police Detective Chris Sasser examined the body and saw the girl's anus dilated and laying open, he concluded she had been sodomized, according to the police report. It was a horrible sight. Rather than use a nearby pathologist, then District Attorney Jerry Jones had the girl's body transported 2 hours away to Mississippi for Hayne to do the autopsy. After the pathologist examined Olivo, he called in West to examine suspected bite marks. So this is where we get what's going on with the funny business. Video captures West's initial examination, starting at 9:35 p.m. He mentions a bruise on her left elbow, possible abrasions and contusions, and visible diaper rash. No mark can be seen on her cheek, and West makes no mention of one. So there's this video, and this is under seal. The victim's family member, I think it was the mother, was saying, we want to see that video. We think people should see that video. We want to see the truth. But in this video, while he's looking at different marks, discoloration, and abrasions, nothing visible on the cheek. Nothing said about the cheek. But 20 minutes later, Hayne telephoned Detective Sasser and said at about the time of the child's death, she suffered lacerations and penetration to the anus, which the pathologist attributed to sexual assault, as well as multiple contusions to multiple surfaces on the body and lacerations and contusions to the scalp, according to the police report. Hayne also said there were adult bite marks on the child made at or about the time of death, and asked for the suspect's dental molds. So he gets the dental molds. Sasser contacts the prosecutor, and then the charge gets upgraded to first-degree murder, which is how we get to death penalty. After the molds arrived the next day, the video resumed. West can be seen jamming the mold of Duncan's teeth into the child's cheek. Now, what do you make of that? There's no mark on the cheek. We just have this guy saying, oh my gosh, there's this crazy stuff. This obviously looks like abuse must have taken place. And even though I didn't mention anything about a bite mark or something on the cheek, get me dental molds. Get me dental molds. And I don't know, this is just somebody's own wording. Jamming. I don't know, maybe if I watched the video, maybe I wouldn't consider it jamming. Maybe, in theory, someone was gently placing it just to see if it fit. But if we take this at face value and jamming, to me, that seems like we're going to create the thing that we are going to claim was already there at the time of death. So West identified these as bite marks belonging to the suspect. Then Hayne comes along and does the autopsy. He concluded that Haley's death was a homicide, that her injuries suggested that she had been essayed at or about the time of her death, and that she had been forcibly drowned. Other pathologists questioned Hayne's conclusions. A grape kit came back negative. The Louisiana State Crime Lab tested Duncan's clothing, the child's clothing, and her bath toys for any seminal fluid, and there was none. In the days following her daughter's death, Statham said prosecutors called her into their office. She said they asked her, and guys, I don't even want to read this, so this is like, they ask the mom if her daughter, who's like 2 years old, ever said or implied that Duncan wanted to her penis like a baby bottle. She told Mississippi Today that her toddler daughter could hardly speak. She could say, I want burgers or I want M&Ms, she said. After she told them no, she said they replied, quote, if you don't tell the truth, you could be implicated. She was 21 at the time. My baby died and the man I loved had been hauled off. She said, it was very intimidating. I was scared, but I wasn't going to lie for them. Now, Tragically, the baby's not alive at this point. So what would have made them ask this? What would have made them even think of words like this? Because personally, my conclusion is they're so sick and twisted, they're thinking of this on their own. They're conjuring this on their own. And there's a reason where I think this is going to get worse coming from the prosecutors and detectives. How do we even get this? And then they're telling her, if you don't tell the truth, you could be implicated. How do you start off by asking someone a question where you wouldn't have heard, like, because the daughter couldn't have said it? Have you ever heard this? They wouldn't know otherwise, but yet they're implying they know for sure. So, let's see. Months later, police got a statement. Here we go, you guys. So right after this all happened, they go to the mom and they ask this very specific question. Months later, they get a jailhouse witness. This is later. They get this statement later. They didn't have this statement when they asked the mom. Months later, police got a statement from jail inmate Michael Cruz. He quoted Duncan as saying the baby pointed at his penis, and he said something about a bottle or bauble. So he's not even sure what the wording was. Where does it sound like Michael Cruz might have heard this from? Cruz later testified that Duncan said he blacked out, and when he came to, he was trying to have sex with the baby and killed her because he couldn't get the baby to be quiet. To demonstrate his innocence, Duncan took a polygraph test. He reportedly showed no deception when he said he didn't kill the child or hold her head underwater. Jurors never heard this because polygraphs are inadmissible as evidence. Now imagine if you're falsely accused and you don't know why the baby died. You just know you walked away and you shouldn't have left the baby alone in the water, right? But then you're being accused of this by some person in jail. And if you were a juror, I mean, I can imagine why a juror wouldn't be able to do anything but believe this person, because why would somebody say something like that? Why would somebody say something like that? Well, let me tell you guys, there are a lot of jailhouse witnesses, and there's always a reason. Promise of less time, promise not to prosecute or prosecute as strongly charges that you're awaiting to face trial for, boredom, nothing better to do, monetary benefits outside of the system. You know, you got family members that are still on the outside. You get some promises, like in the Brittany Drexel case. They finally got the actual killer to confess by saying they would let go of the seizure of some of the assets in his estate that he wanted to leave to his grandchildren. So that obviously doesn't benefit him directly. He's still behind bars, but they used it as leverage to get him to confess. So Brittany Drexel, another major case that they accused a totally random person of, made him say that he did it in a plea deal, and then the real killer and his girlfriend at the time they finally find out they're the ones that actually did it. So Brittany Drexel case is another one to look at if you want to see some crazy leaps from prosecutors. Let's see. So we got this jailhouse quote. To demonstrate his innocence, Duncan we did that one. By the time the trial began in 1998, much of the important physical evidence was gone. The rape kit had been lost. So had Hayne's autopsy slides. They're just gone. Samples of her blood that no one had tested for toxicology, a standard practice for autopsies, had been destroyed. So had Hayne's detailed reports on his slides. So guess what? We don't have any of the stuff that Haynes actually did. What actually gets to be discussed at trial? All that experts had available to examine were Haynes' autopsy report and a few photos of the child's body and injuries. In his opening remarks, guys, this is crazy. This is why I'm like, we have to do a stream, because this is where I really get pissed off. These two paragraphs together, Well, the third one. There's going to be a third one down here. The next 4 paragraphs we read are going to be very heinous descriptions. The 4th paragraph is going to be the oh my God moment. In his opening remarks at the 1998 murder trial, the district attorney said Duncan, quote, rode that baby like a bull, and, quote, in a sexual frenzy, bit her behind the ear, bit her elbow. She screamed, and she died in a bathtub full of water so bloody you couldn't see the bottom. Now, this would lead you to believe there was blood at the crime scene. There was a photo maybe, and police walked in and there was a bloody bathtub. So much that you can't see the bottom of the tub. How would you even come up with something like this if you didn't have evidence of this? This is opening statements, which I think that anchors jurors. I think there was probably at least a few jurors that were done as soon as they heard this language. Like, give him the chair. Because this is as an accusation, if you take it at face value, this is disgusting. This is heinous. With West's credentials now under question, prosecutors relied on another expert who looked at West's photos. So West isn't good. We don't want to put him on the stand. So we'll just bring in another expert to rely on the limited stuff made available from West to this new expert witness we're going to bring in, who on the outside has more credibility. So this expert witness looked at West's photos and identified Duncan as the one who had made bite marks on the child. That expert didn't see West's video, so he didn't see the jamming. Neither did the defense experts because it wasn't disclosed. And of course, neither did the jury. So they hear in opening statements, there's bites, she's bit, and they have an expert relay from another expert who's now disgraced. It was a match to Duncan. Hayne backed up the prosecution theory that Duncan drowned the child to cover up his sexual assault. He told jurors the bruise on her head was, quote, consistent with a digit, such as a thumb or finger pressing down on the back of the head, rather than if the baby had had a seizure and maybe fell and hit their head. Asking if the child could have suffered a seizure, Hayne said no, because the brain showed no sign of seizure activity. This is the guy that is barred from doing autopsies. The one who said he removed ovaries. And they were like, wait, how did you remove ovaries? This guy didn't have ovaries. This is the guy who made the conclusion. I looked and there was no seizure activity. Hayne testified that the child wouldn't have survived her anal injuries, and another doctor told jurors there would have been so much blood, it would be like someone having their head cut off. Now, this is the 4th paragraph I was talking about. But police never found a drop of blood anywhere in the house, never found any evidence of cleaning. The detective later said if there had been any blood or semen at the scene, they would have discovered it. And remember the timeline, you guys. Mom leaves to go to work. The boyfriend's making oatmeal. Baby's in the tub. When he hears something, according to him, and again, we could assume that he's lying, but there's still a point in time where he runs with the baby to the neighbors trying to get his neighbor to do CPR. And one of the neighbors actually ends up doing CPR. So, I mean, this would otherwise mean that you'd have to clean down everything before running and grabbing the baby up from the bathwater. There should, in theory, be blood. The neighbors should have seen blood. Like to me, this was it for me. There should have been blood on the baby. The neighbors should have seen blood. There should have been bloody water on the clothes. And I don't know how this guy would have had time to clean down an entire bathtub area. Hayne testified that fragmented tomato, pickle, and onion were in the child's stomach, but no oatmeal. A detail prosecutor seized on as proof that Duncan concocted this story to conceal his horrific crime. When police arrived, they found oatmeal in the kitchen, in the bathtub, and on Duncan's clothing. The neighbors saw uncooked oatmeal when he cleared Olivo's throat before performing CPR. The prosecutors told jurors the uncooked oatmeal was proof he planted it. The jury convicted Duncan and sentenced him to death. So, we got a pull quote here for bad medicine, bad science, and bad lawyering. Tucker Carrington, who wrote a book on Hayne and West with journalist Radley Balco, and I think we'll hear a little bit from Radley Balco when we go over to the Reason article. Um, they called this the Cadaver King and the Country Dentist. So the Louisiana case bears similarities to the case of Jeffrey Harvard, convicted of capital murder for allegedly raping and killing an infant in Natchez in 2002, thanks to Hayne's testimony. Harvard has said he was bathing his girlfriend's 6-month-old baby, Chloe Britt, when she slipped from his hands and hit her head on the toilet. But as in Duncan's case, law enforcement officers thought the baby had been SA'd. At trial, a parade of doctors and nurses testified about anal rips and tears they saw, describing the worst anal trauma they had seen, and prosecutors called Havard a monster. The autopsy report, however, showed no such damage, only anal dilation and a small contusion. The rape kit came back negative. So how do we get all these people saying that they saw it, but then the autopsy doesn't have that? Despite that, Hayne's testimony backed the prosecution's theory of SA, and Havard was sentenced to Mississippi's death row. After examining the case, renowned pathologist Dr. Michael Baden, so familiar name here, shout out to Justice Served. That's who sponsoring my iced coffee this morning. But that is Linda Kenny Baden. That is her husband. He's done a ton of work as a forensic pathologist. So what does he say? He takes a look at this case. Dr. Michael Baden concluded that Britt's injuries were consistent with her being accidentally dropped and that she wasn't sexually assaulted. Quote, dilation of the anus occurs normally in children when they die as muscles relax, and when seen by a casual observer, can be misinterpreted as evidence of perimortem penetration, he said. Other pathologists agreed with Baden that the anal dilation had been misread as abuse, and in 2014, Hayne told a reporter he didn't believe a rape took place. He said the anal contusion could have resulted from a bowel movement. So, he originally testified that the baby had died from shaken baby syndrome. Now he said he didn't believe that was true because science had since determined such conclusions were flawed. At least 37 people have been exonerated in shaken baby cases after being wrongfully imprisoned, according to the National Registry of Exonerations. And I caught wind, I haven't looked into the case, but I believe there's a death penalty. There's an execution that was put off a few months ago in Texas involving shaken baby. Like shaken baby syndrome was the testimony at trial as the cause of death, and the guy was convicted. I don't have a deep dive on that case though, but there's still, even though shaken baby syndrome is kind of off the table, there's still people behind bars and on death row for it. So destined to be, I think, let's reread that. Okay, Havard said he was bathing his girlfriend's 6-month-old baby, Chloe Britt. So the baby is the she. When she slipped from his hands, so baby slipped from his hands and hit her head on the toilet. Oh my gosh, be careful with babies, guys. Especially a slippery baby. Let's see. Havard's lawyer, Graham Carner of Jackson, said the case is filled with bad medicine, bad science, and frankly, bad lawyering. After a 3-day hearing where the defense called Hayne to testify, the trial judge reduced Havard's sentence from death to life. His appeal for freedom is now pending in U.S. District Court. And this is a quote here from the attorney, Graham Carner. Innocence is different than not guilty, and innocence is different than you didn't get a fair trial, Carner said. But I believed as soon as I dug into Jeffrey's case that he was an innocent man, and I believe that to this day. Science, like law, evolves over time. The damage that Hayne and West have done to Mississippi is immense, said former state Supreme Court Justice Oliver Diaz Jr., and he is stunned the state has never reviewed their cases for possible wrongful convictions. They operated in Mississippi for years unchecked, he said. Mississippi used Hayne as a state medical examiner, even though he did not meet the statutory qualifications. Statutory is not really a subjective thing, you guys. It says this person should have at least this. Hayne's testimony helped convict Tyler Edmonds, who was just 13 when he falsely confessed that he and his half-sister had both killed her husband. He said, what? He said she had told him she would fry, but he would go unpunished. At trial, Hayne testified that the fatal wound was consistent with two people. Oh my gosh. This part, guys. Hayne testified that the fatal wound was consistent with two people pulling the trigger. How does one determine that? How does one determine that two people were holding the gun? What kind of forensic science is that? Like, what is the class I can take to determine this and sharpen my skill set? But to be fair, he did say it was less likely. So he said, I can't exclude one shooter, but I think that would be less likely. Like, what? The Mississippi Court of Appeals concluded such testimony was scientifically unfounded. Quote, you cannot look at a bullet wound and tell whether it was made by a bullet fired by one person pulling the trigger or by two persons pulling the trigger simultaneously. Like, what? So this is the Supreme Court Justice Oliver Diaz Jr., who's stunned. If they want to convict two people, can you imagine if in the YSL trial, when we're trying to figure out, you know, who actually shot Shamel Drinks, who was sitting where in the car, or Donovan Thomas, who was in the vehicle? We're going to blame four people for this. We're going to change which four people it is before we actually solidify our indictment. Can you imagine if they got up there and Atkins gets up there, Hilton gets up there, Love gets up there, and they're like, well, we submit to you that Shannon Stillwell and Amikian Garlington were holding the gun at the same time. Evidence will show. Like, what? Oh my gosh. So Diaz, this is the Supreme Court Justice, said Hayne's testimony prompted him to dig deeper. Two hands on a trigger? You don't have to do any research to know that's ridiculous, he said. That's what led me to look at Hayne closer. What he found was disturbing. He didn't realize Hayne was essentially acting as state medical examiner, but he wasn't a board-certified pathologist. Diaz wound up writing a scathing dissent centered on the pathologist that prompted other justices to change their minds. And that's kind of cool to hear because a dissent is usually like, well, the others made their decision. I'm just going to tell you why I disagree. But this dissent, the justices were like, well, actually, hold on. So in this dissent, he said, as science, like the law, evolves over time, one generation's expert is another's quack. So that is memorialized in this justice's dissent. He now regrets the first vote he cast on the High Court, a death penalty case that relied on the words of Hayne and West. He said, based upon their testimony, my first Supreme Court vote was to execute an innocent man, Kennedy Brewer. He and other justices later supported the dismissal of Brewer's conviction, and his last opinion called for the end of the death penalty. It's not a workable system when errors like this can take place, he said. No matter how careful we are, we're going to vote to execute innocent people. So there we go. That was a side story case, but some important words there from the justice. Now we're going to go back over to the case with Jimmie Duncan. So what the jury never heard. In November 1993, Statham brought her daughter twice to the hospital for seizures after she stopped breathing. One doctor suggested she could be suffering from Stevens-Johnson syndrome, a potentially life-threatening reaction, often to medication. Now, we saw earlier that there was nothing in the toxicology. There was no record of a toxicology report, which is standard for autopsies. And you might be thinking, well, so what? It's a baby. Why would they have been doing anything? And it's not like the cause of death is alleged to be an overdose. But if there was medication, and medication here could mean something like Tylenol. If medication could trigger this type of seizure, and there was evidence that, maybe she was given medicine, maybe she wasn't feeling well, maybe she was running a light fever the day before, it'd be more believable, more likely that maybe she did in fact have a seizure. We got the contusion on the back of her head that prosecutors swore was a thumbprint. So let's see. So Stevens-Johnson syndrome can cause lesions in the mouth and in the genital area. The disease can also cause seizures. What a poor baby. Nearly 3 weeks before her death, a chest full of drawers fell on Haley. There's so much in here about how, like, keeping a baby safe, you guys. Like, anytime I've gotten furniture, they're always like, make sure that it's stable. And they always have the image of, like, if it's not affixed to the wall and stabilized, that it could tip. And they'll put like a little doodle cartoon drawing of the baby. And here we are, like, we have the baby alone in the bathtub, unmonitored, which, of course, even if a baby wasn't at risk of seizures, is still, that can be a dangerous thing. It's even more dangerous if there's a likelihood of a seizure. But here, the chest of drawers also fell on Haley 3 weeks before her death, nearly 3 weeks before her death. So she suffered 3 skull fractures and a subdural hematoma that caused her to spend 6 days in the hospital. So this is, again, what the jury doesn't hear. This is under the what the jury doesn't hear section. Duncan and Statham, so this is the mom and the boyfriend, told Child Services that she'd been climbing to reach her piggy bank. Oh. But the jury never heard about this serious injury because of a deal that Duncan's original lawyers made with prosecutors. Okay, give them the ineffective assistance of counsel 1,000,000%. Oh, pathologists say it's critical to know everything possible about a person's medical history before drawing conclusions about a death. Testimony shows police knew Olivo's medical history, but it remains unclear if Hayne knew that history before concluding she'd been raped and killed. And I mean, even if it remains clear if he knew, it seems like there's reason to believe that he would have disregarded such information anyway. In a 6-day hearing last September, 2 pathologists called Hayne's conclusions unfounded, said they saw no evidence of a rape or homicide, and believed Haley drowned accidentally, perhaps after suffering a seizure. In one sworn statement, former jail inmate Michael Lucas said he heard Duncan tell Cruz that he didn't kill the toddler. An investigator testified that Cruz now admits he lied at the 1998 trial because he wanted leniency for the felony he was facing. So going back to why would somebody in jail lie, what difference does it make? Well, he wanted leniency for the felony he was facing. So again, to me, it's very sick and disturbing. If they went to the mother and used the language we read earlier about, did your baby say this to you ever? This disgusting thing. It's disgusting that the police even originated that language. They fan fictioned it. And when they couldn't get the mom to agree right after the alleged crime had happened, months later, they're trying to get a jailhouse witness to say they overheard their suspect say this thing. They fan fiction that language. To me, that's disturbing. Why would you even think of that? It's just gross. And then again, I think that opening statement language is gross. It's like they fan fiction the language in the opening statement. Extremely heinous and graphic fan fiction language. And I think it's disturbing that someone even originated that. Let's see. Brooklyn says, wasn't that the argument in Phil Spector case that Lana Clarkson and Phil's fingerprint were on the same spot? So maybe that detail, I don't know. But, that's a pretty high profile case where I'm sure there were discrepancies like this, right? Peter says, what did the defense get in return for agreeing to the deal? They don't specify, but maybe it was something like, maybe they will further in this article, but maybe it was just something like, all right, if we can't bring that in, we won't bring in this other like really damaging thing that our expert witness is going to say. Right? So I would love to know. But wow. And shout out to Terry Friday. It is Friday. Says, wouldn't the mold of his teeth be the opposite of his actual teeth, though? Unable to make the mark. Yeah, I mean, I would say so, because the mold is what you'd actually put in to create the replica. So But I don't know if he was the only one examining his results and then passing it on to an expert for the expert to testify that, yeah, I'm reading his report and Hayne concluded, because I'm just relaying what's in his report, he concluded that the bite marks were a match. Right? So this isn't getting in front of the jury. The jury isn't actually able, I mean, the defense attorneys, they could say, well, you didn't actually do this work yourself. You're relying on his report, right? So you don't know if he actually did this or did that, right? But they weren't actually able to cross-examination Hayne himself. So, and there's obviously an ineffective assistance of counsel thing going on here, which seems like maybe a substantial actual ineffective assistance of counsel. So you are absolutely right. But with the layers there and the defense attorneys, it's possible they didn't even underscore that. And shout out to Amy E. Thanks for the reminder. Good to see you. Says, please be sure to click the like button. So, and Tech Cloud's in the building. The family's all here. So let's see. Duncan's lawyers told those at the hearing that they planned to show West's video involving Haley, warning that it was graphic and disturbing. An excerpt of that video had first surfaced in 2009 when the Reason website published it. Oh, is that there? The video appalled many in the legal and forensic science communities. The video shows, so that, do they actually have it, guys? Let's see. We can view a portion. No, why did they do the art? Look at the artwork they did. So no, they don't have it. But there's a description in this other article. So they say that they examined the video twice, on December 18th and 19th, 1993. Let's see. What's not routine is that the video seeing the light of day. We couldn't open this. For the first 5 minutes, Wes examines Olivo's body, noting bruises, signs of livor mortis, which is the pooling of blood after death, abrasions, and contusions. During this time, he makes no mention of any scrapes or abrasions on Olivo's cheek, nor are there any apparent on the tape. So we have Reason, whoever's looking at it, also saying we don't see anything. At 4:57, there's a break in the video, marking the lapse between the two exams. At that point, the camera returns to Olivo's face. Strikingly, where just moments before the video showed no blemishes at all, there's now a conspicuous bright red abrasion to the right of Olivo's mouth. Wes' hands then enters the frame, holding a plaster dental mold taken earlier that day from Jimmie Duncan. Using the replica of Duncan's teeth as a weapon, West repeatedly presses and jams the front bite plate directly into Olivo's cheek. Over 2 minutes, he does this 17 times. At 6:57, he starts dragging Duncan's mold across Olivo's face, beginning near her lips, then scraping the plaster teeth down her face to her jaw. He does this for another minute. West next moves to Olivo's elbow and uses the cast to impress Duncan's dentition into an old bruise hospital records show she suffered weeks before her death. So they're taking the bruise from the dresser falling, and he's putting the mold in that lasting bruise. At the 9-minute and 32-second mark, Wes asks someone in the room to turn out the lights. A fluorescent black light flicks on. Wes is now employing a much ridiculed technique he invented for identifying bite marks, which he modestly calls the West phenomenon. Oh my God. He claims that by using a black light and yellow goggles. What? Why does he need yellow goggles? He can find bite marks, knife serrations, and other tears and abrasions to the skin that no other expert can see. Guys, what? What? I shouldn't be laughing. This is awful, but it's so ridiculous. The West phenomenon, things that only I can see. It can't be replicated, chat. This is great science. He brags that this cannot be replicated. With the lights out, Wes continues to jam the plaster cast into the girl's cheek, elbow, and arm. Over the course of the 24-minute video, there's like charges for like defiling a corpse, right? And it can be all different things in different states, but they should have gotten this guy with that. Over the course of the 24-minute video, Wes pushes the cast of Duncan's teeth into the girl's body at least 50 times. He's tampering with the evidence, the body. It's criminal. This is the best documentation I've ever seen of Dr. West's junk bite mark comparisons, says Michael Bowers, a deputy medical examiner for Ventura County, California, after viewing the video. This looks like a different link, actually. Let's see if this one works. I mean, I don't know if I want to watch it, you guys, to be honest, but I don't think it has it anyway. It's just, yeah, so I don't think they have it anyway. But what I think is nice is that there are other people that have seen this that aren't on the defense team, right? It's not like we're just getting a defense attorney saying, oh, he's and exaggerating something. These are independent parties that have looked at this video and they're all astonished by the horrible stuff they're seeing this stand-in medical examiner do. So I will share this link if you guys want to check it out. This is the one that's currently on the screen. But yeah, we'll go back to the one we're reading because it seems like the same material, the same characterizations and description. So, a past chairman of the American Board of Forensic Odontology's Exam and Credentialing Committee, Bowers also worked with the Innocence Project to help free Kennedy Brewer. So we read a little bit about Kennedy Brewer, another dentition case. Kennedy Brewer's the one where 2 separate infant deaths with grapes, 2 different men convicted, and then really the culprit was one person that did both the crimes, a serial killer. But dental matched these 2 individuals to 2 different bodies, even though it was all one other individual, a third individual. How did abrasions that were not apparent on December 18th suddenly appear bright red the following day? Dr. West created them, Bowers said. It was intentional. He's crafting artificial abrasions in that video, and he's tampering with the evidence. It's criminal, regardless of what excuse he may come up with about his methods. You never jam a plaster cast into a possible bite mark like that. It distorts the evidence. You take a photograph, or if there are no indentations, you make an impression. But you don't jam plaster teeth into them. After watching the video, Bowers offered to submit an affidavit for Jimmie Duncan's defense. David Averill, a former president of the American Board of Forensic Odontology, concurred. The video is troubling, Averill says. I don't know how you can explain where those marks come from. And there's just no justification for him to push the cast into the skin like that. That isn't an acceptable way to perform a bite mark analysis. Now, remember, we've heard they've overturned 10 cases involving West and or Hayne, but there's hundreds of other cases. So what else is out there? We've got more criticism from San Diego forensic pathologist Harry Bonnell, who was hired by Duncan's post-conviction attorneys last summer, also concludes that West broke the law. Bonnell formerly served on the ethics committee of the National Association of Medical Examiners. He has worked for the Armed Forces Institute of Pathology, and he now sits on the board of trustees for the advocacy group Parents of Murdered Children. He has previously described Hayne's work on homicide cases as pathetic, near total speculation, and bordering on criminal negligence. By email, Bonnell says, if what I'm seeing on the video is accurate, someone is using the mold of Duncan's teeth to create an apparent bite mark. This, in my mind, is criminal tampering with evidence. In his affidavit for Duncan's defense, Bonnell writes, the injury to the cheek of Haley Olivo is not seen in hospital photos and was generated by using a mold of Duncan's teeth to create a bite mark. Of the alleged mark on Olivo's elbow, Bonnell writes that it, quote, does not appear to be acute or occurring at the time of death. It appears older and is certainly not a bite mark. Richard Silveron, a bite mark examiner, they are just tearing this guy apart. A bite mark examiner in Miami and a founding member of the American Board of Forensic Odontology, testified for Duncan's defense at trial. Inexplicably, Duncan's trial attorneys, who had access to the video, never showed it to him. Peter, where are you? Peter, you hear this? Wow. I feel like this was part of the deal then. Shame on these defense attorneys. So you get an expert to testify at trial for the defense, but you don't show him this video. So the same expert witness, after viewing the video last year, which this recent article is older, but this is after the trial. So he gets to view the video after trial. The same expert witness filed a new affidavit that describes, quote, Dr. West violently and repeatedly forcing a mold of Jimmie Duncan's teeth into Miss Olivo's right cheek. In doing so, Soveron continues, Dr. West creates a mark that was not previously present. Dr. West's behavior and methods are absolutely not supported by any scientific standard or protocol. Soveron adds that the abrasions could not have been created by Jimmie Duncan, but rather were created by the flagrant misconduct of Dr. Michael West. Like, that's just gross. So, yep, the video was never shown at trial. And the alleged manufactured bite marks proved to be a critical piece of evidence in Duncan's 1998 conviction on charges of rape and murder. He's been on death row for 10 years, awaiting lethal injection. And this article's old, in part because of evidence that several prominent forensic specialists say was fabricated. So they've got more on this story, you guys. Let's see. We're going to read this other thing that's linked here. So if you want to continue reading this article, this is all on the video. Examiners revisit video. Or review video, because it's not really revisiting if they never saw it. So there's that in the chat. Hey, Nicola, good to see you. And hey, Angelica. I enjoyed Angelica. I think you were behind when we were all in the stream yesterday with Happily Angry Lawyers Fulton County rants. I think you were behind on the chat, but you were commenting. You're like, oh, I just got to this part. I enjoyed watching your commentary through and through. And Nick Starro. Oh my gosh, Nick Starro heard junk science, bite mark science, and must have just been summoned to this stream. So yeah, we were going over one of Nick Starro's favorite topics, you guys. Make sure you check him out because he's still doing a ton of content covering trials. I know I haven't been around, so fill your time with Nick Starro. He also says, happy birthday, USA. So here we go. Today is all about freedom and being aware of junk science that leads to wrongful convictions. Let's go back to where we left off here before we went on that article with the details about this video of the jamming of the dentition and creating the marks post-mortem. The video appalled many in the legal and forensic science communities. So we know that it showed the jamming, dragging, and scraping of Duncan's dental mold across the child's body dozens of times. Some of those in the courtroom gasped. Some covered their eyes, and others, including Duncan, wiped away tears. So this is when they're showing it. Let's see. Did they give a date? This is the last September, and this was just a few months ago. They show this to people in 2024. And this is the reaction it's getting from the courtroom, but it was never shown to the jury at trial. After seeing the video, Lowell Levine, past president of the American Board of Forensic Odontology, called what West did fraud. In 2009, the National Academy of Sciences concluded there was no basis in science for forensic odontologists to conclude a person is, quote, the biter, to the exclusion of all other suspects. Adam Freeman, past president of the American Board of Forensic Odontology, testified that the bite marks identified on Haley weren't bite marks at all. He called these determinations junk science that can't be defended scientifically. In 2015, he helped conduct a study on the reliability of bite marks. In all but a few cases, board-certified dentists couldn't even agree if they were looking at a bite mark. As a result, he resigned from leadership in protest and stopped doing any bite mark analysis. So I kind of love this because it seems the way this is worded, right? It's just a quick paragraph. But it seems like he went into this study like trying to show it was somewhat reliable. And then by the time he actually got done with it, he's like, he looked at what the results were and were like, nope, this isn't the conclusion I expected, and I can't support this type of analysis anymore. So shout out to someone actually following the science instead of making the science follow the conclusion. Oops, what did I click into? So nationwide, at least 34 wrongful convictions have occurred since 1989 because of bite marks. 6 of them in Mississippi that all involve West, according to the National Registry of Exonerations. And remember, we've heard twice in this article that we haven't even looked through the cases that West was involved in. Dr. Robert Bucks, who served as chief medical examiner for the El Paso County Coroner's Office in Colorado Springs, questioned how Hayne could say the child's injuries matched shoving her face underwater. If that were so, I'd expect to see injuries on the front part of her body, particularly on her forehead or nose, cheeks, interior parts of her shoulders, interior parts of the knees, said Bucks, who helped investigate Pat Tillman's death in Afghanistan. The autopsy showed lacerations to the anus. Bucks said that these could have been caused by an infection, a diaper rash, a hard stool, or vigorous washing. There's no way to know. You have to look at it microscopically, and it wasn't looked at, he said. Up until 2007 or so, people believed anal dilation proved sexual abuse, he said. A dilated anus means nothing. We saw it all the time in adults and children. And that just kind of, like, side story, not to be gross, but that just makes me think of, like, when people die, they can, like, defecate, like, their stuff releases. So to me, that kind of seems like common sense if we're not analyzing it for other signs or to look at the causes. The relaxation of the muscles seems to make sense to me. The lack of blood at the scene suggests something other than a violent assault, he said. It's absolutely bloodless. I mean, where is the blood in the sink? Where's the blood on the victim? He rejected the claim by Hayne that the child stopped bleeding because she was dead. Blood gives way to gravity, he said. And not for nothing, but if he's accusing someone of getting, like, marks on their head while they're being held down, you would think that there would be some bleeding during the process. I don't even want to indulge on thinking about the process. It'll come out drip, drip, drip. So you're going to see it, and you're going to see it for hours, and you're going to see it for days. I don't think you can just wash that off because it's going to continue to ooze out after she's dead. Ugh. Her death appears to be a tragic accident of drowning, he said. I don't see any evidence to me that would support that it was forced. She drowned, possibly because she suffered another seizure, he said. But I can't prove that because Hayne didn't do any investigation that would help us on that. Hayne's lack of research and examination prompted Duncan's lawyers to ask twice for the exhumation of Olivo's body before the 1998 trial. The judge denied the requests. Her mother said if her daughter's body needs to be exhumed to answer any questions, she supports that. It might give us some answers to what happened then, Statham said. I wonder, 1998 to now, I wonder if they could still, I'm just kind of, curious in a nerdy way what the difference of decades would make in a determination. Would it be impactful to do this now? Let's see. If prosecutors win their appeal, Duncan would remain on death row and face execution. ProPublica and Verit reported that Duncan's bid for freedom has become more urgent, with Louisiana Governor Jeff Landry pushing for executions. In March, Louisiana held its first execution in 15 years, using nitrogen oxide to put Jesse Hoffman Jr. to death. If Duncan faced another trial, jurors would hear a much different story, his lawyer said. Rather than the state's sensational story of pure horror, including rape, biting, blackouts, a panicked forcible drowning, and a cover-up involving massive quantities of blood, that Mr. Duncan, cold and calculated, cleaned up before seeking help for the child, the jury would instead hear the true story. Haley tragically but accidentally drowned in the bathtub. After the 1998 trial, Statham spiraled downward. She could have survived her daughter's death, but surviving this horror story proved nearly impossible, she said. Duncan's conviction didn't just destroy his life, she said. All of our families were destroyed by this, and we're still collateral damage in this. So this is the Mississippi article we just read here. And I think I said earlier, and my bad, but this was a Louisiana case, but it's being covered by Mississippi today because these same experts also impacted cases in Mississippi. So that was incorrect at the beginning of the stream where I said this was a Mississippi case and a Mississippi exoneration. I will make a pinned comment. Let's see. We've got, where did the reason? All right, so this is the second thing I wanted to look at. This is from 2007, you guys. So this is a bit older. And let's put it in reader mode. All right. So again, 2007, and this is from Radley Balco. Miss Stevie, good to see you. Yeah, you're about to say how I miss my own state case. We did get examples of cases in both states, and I think they're going to bring in some Texas cases here as well in this write-up from Reason. So, a case study in expert testimony gone horribly wrong. And I think we've got some backstory here. I think we can agree with where this one's going to go. I think this is a bit... Make this bigger that way. No, I keep covering the words like this. I'll just try to scroll as we go. So, in a remarkable capital murder case earlier this year, the Mississippi Supreme Court, by an 8-1 vote, tossed out the expert testimony of Stephen Hayne. The defendant was Tyler Edmonds, a 13-year-old boy accused of killing his sister's husband. Hayne, Mississippi's quasi-official state medical examiner, had testified that the victim's bullet wounds supported the prosecution's theory that Edmonds and his sister had shot the man together, each putting a hand on the weapon and pulling the trigger at the same time. This is just like unlocking a new way for YSL prosecutors to get two people for one murder. Quote, "I would favor that a second party be involved in that positioning of the weapon," Hayne told the jury. "It would be consistent with two people involved. I can't exclude one, but I think that would be less likely." Testifying that you can tell from an autopsy how many hands were on the gun that fired a bullet is like saying you can tell the color of a killer's eyes from a series of stab wounds. It's absurd. Yeah, the pattern of these stab wounds, he was clearly brown-eyed. He was green-eyed. Oh, this other one, that's definitely blue eyes. like what? The Mississippi Supreme Court said Hayne's testimony was, quote, "scientifically unfounded" and should not have been admitted. Based on this and other errors, it ordered a new trial for Edmonds. But it wasn't the doctor's dubious claim that made the case unusual. It's the fact that the court explicitly renounced his testimony. It was the first time that happened to Hayne in hundreds of cases dating back nearly 20 years. By any sane standard, what kind of standard is that? By any sane standard, the decision was long overdue. Hayne's career in court is an egregious example of what happens when the criminal justice system fails to adequately oversee expert testimony. We've got recent examples of this with Karen Reed. We've got the YSL trial, good old expert testimony. Good old Dauberts. Experts coming in and telling us what lyrics mean because the jury can't figure it out for themselves. He may be unusually careless, but he's not unique. Not in Mississippi and not in the United States. During the last 2 decades, there have been more than a dozen high-profile cases in which dubious forensic witnesses conned state and federal courts, sometimes for many years and in hundreds of cases. The most famous example is probably the West Virginia crime lab worker Fred Zane, who from 1979 to 1989 tainted so many trials of false testimony about blood, semen, and hair evidence that the state Supreme Court ordered a review of every case in which he'd ever testified. It turned out that he introduced deliberately falsified evidence in at least 134 cases. And one of my pet peeves, you guys, I say it in a lot of contexts, but I think it's a very privileged position to be able to ask yourself, or to be able to conclude that somebody's guilty because somebody else said that they did it. The "why would somebody lie" is a natural question to ask. But if you ask, why would somebody lie? And that's it for you, you conclude that nobody would ever lie. So what they're saying must be true. I think that's just a really privileged position where you've never, either yourself or somebody you know, have dealt with a situation where somebody has lied about you. And here, this lie is in the criminal justice system context, where this expert witness is coming in and deliberately lying to a jury in 134 different cases. And what's on the flip side of these lies? Most likely a conviction where somebody is now wrongfully incarcerated. Right? It's not just a white lie like, you look good in that dress. Wink, wink. Then there's a disgraced Texas medical examiner, Ralph Erdmann. Profiled in Barry Scheck, Peter Neufeld, and Jim Dyer's 2000 book Actual Innocence, Erdmann dubbed himself the Quincy of the Panhandle after the TV series about a paraparetic medical examiner. Erdmann claimed to perform around 400 autopsies per year. That's an autopsy a day plus, a number Scheck calls astonishing. His workload was so heavy, he sometimes skipped doing autopsies altogether. Wait, so are the autopsies he's skipping being counted in the 4 autopsies? Like he's just marking them complete but not actually doing them? Oh, crap. He once delivered a body without a head. In another case, his report included... Like, did he just leave it behind? In another case, his report included the weight of the victim's spleen and gallbladder, which the victim's family found odd since both had been removed while the victim was alive. After authorities caught on to him in 1992, Erdmann was found to have faked more than 100 autopsies. Jesus. More recently, like what were you doing all day? More recently, Oklahoma City was forced to review nearly 1,200 cases after the FBI found significant flaws in forensic analysis done by the police chemist Joyce Gilchrist, including problems with her hair and fiber analysis. In court testimony, she presented as fact that other experts say was clearly opinion. Well, that's nothing new, right? I think I think every case that we've talked about on this channel with an expert witness, we've ended up, that's an opinion. That's not beyond the ken of the jury. Why are you testifying to this as if your expertise has to make this determination? The investigation resulted in one man's release from death row. Gilchrist, in turn, was fired. 2 more death row inmates were released after investigations found errors by other state forensic experts. Such misbehavior and incompetence, this is gentle here, has persisted partly because of the complicated, highly specialized nature of the relevant fields. But Zane, Erdmann, and Gilchrist were at least eventually exposed. So, and again, this is 3 names. This isn't including Haynes or West. So total from today, we're at 5. We're at 5 people that were intimately involved in prosecutions of individuals where they've done the same work that was found to be flawed hundreds of times. They've done this work hundreds of times, and it's been found to be flawed multiple times. So just think about how that can ripple and scale. Good to see you, late night baking with Mookie Mookie. It's quite early. So good to see you, and hey to Dolly Talk. I've been loving hanging out in Dolly Talk's court roulette. There's been some great stuff going on in, what was it, 2 days ago? Judge Simpson. You guys all love Judge Simpson. Told an attorney to get control of your client. The client had asked, what did he say? He asked Judge Simpson something, and Simpson's like, because that's my job. And he kicked the client out of the courtroom. Oh my goodness, that was a good time. So if you love watching different courts, he does a roulette where he skips over to McBurney and Judge Simpson and a few others. It's an amazing time over there. And heck yeah, KSPN. See, if an expert witness were to tell us about KSPN, I would believe it. So what else do we got? We got all these names. And then Hayne's highly questionable practices are well known in Mississippi and neighboring states and to forensic experts across the country. Yet he has been working in Mississippi for 20 years. So again, this article's from 2007. He still does the vast majority of forensic autopsies in the state. A forensic autopsy is done to determine if the deceased died as the result of crime or negligence. Other types of autopsies are done if the deceased died of a pathogen, cancer, or medical disorder. Cool. Yeah, and that seems obvious, but I think it's cool to read the distinction. So he's doing the vast majority of autopsies that would be to determine whether or not a crime occurred. Hayne, 67, has a reputation for threatening to sue his detractors. Oh my God. Which makes many of them reluctant to speak on the record. When reformers tried to make Mississippi abide by the professional standard of forensic pathology, Hayne and his allies sabotaged their efforts, and in some cases effectively drove them out of the state. Hayne himself did not respond to multiple requests to be interviewed for this story. Phone and email queries to the Mississippi Department of Public Safety, which oversees the state medical examiner's office, and the Mississippi Attorney General's office, also went unreturned. So this is interesting. This seems like a side story, but it seems really interesting. I mean, what exactly does this mean? So they want to enforce the standards of forensic pathology? Well, they're not even asking to reform it. They want to enforce what's already in place. And according to this article, Hayne and his allies sabotaged that effort. And while I'm not doubting that, I would still like to know what this actually means, because right now it's just a vague statement. But that seems like an interesting side story there. Still, several of Hayne's critics were willing to speak publicly about him, and what Hayne himself has conceded in trial testimony and at depositions is damning enough. J.D. Sanders is a former Columbus, Mississippi police chief who now works as an assistant police chief in Franklin, Tennessee. Quote, "There's no question in my mind that there are innocent people doing time at Parchman Penitentiary due to the testimony of Dr. Hayne," Sanders said. "There may even be some on death row." So this is coming from, it seems like while he was working in Mississippi, he had more exposure to investigations and prosecutions where Dr. Hayne played some role, either at the autopsy or testifying at trial. So that's kind of a bit refreshing to see this awareness from a police chief. Ken Winter, who was director of Mississippi State Crime Lab from 2001 to 2004 and currently serves since 2007 as executive director of the Mississippi Association of Chiefs of Police, observes that prosecutors think Hayne is an excellent witness. Oh my God, of course they do. Of course they do. Of course prosecutors love him. But there's a lot more about being a professional and doing a good job than being an excellent witness. Leroy Riddick, a state medical examiner in Alabama who has testified in opposition to Hayne, adds, "All of the prosecutors in Mississippi know that if you want to be sure you get the autopsy results you want, you take the body to Dr. Hayne." Oh, I think this guy is saying what I'm thinking. And that's the problem. The aim of expert testimony should be getting at the truth, not pleasing prosecutors. According to the standards set by the National Association of Medical Examiners, the field's shorthand as NAME, the field's preeminent professional organization, medical examiners, quote, "must investigate cooperatively with, but independent from, law enforcement and prosecutors. The parallel investigation promotes neutral and objective medical assessment of the cause and manner of death. That isn't happening in Mississippi." Now we're going to go more into the casebook of Dr. Stephen Hayne. There's more, chat. There's more. Hey, Rain. Good to see you. Dolly Talk says, "LOL, yesterday we had someone tell Judge Simpson he was the alpha and omega and went on a rant about his sister wives and how the devil is inside Barack Obama. Always a good time in Judge Simpson's court." Yeah, I didn't get to tune in yesterday because of work. Oh, man. So that will be on my watch list for later. Oh, my gosh. Ms. DB says, "Our crime lab is extremely backed up here in Mississippi with mostly murdered victims." And that's true as well with false documents concerning autopsy reports. And that's the thing, right? So we've got these things that are backed up And a backlog is a backlog that can be a separate issue than medical examiner malfeasance, right? A backlog is one thing. But what I think is interesting is we're hearing here that this guy was just skipping autopsies, and it's presumably it seems like he's marking them complete, but he's not actually doing them, is what they meant when they said that. That's not the way to clear a backlog. So, loving here the local feedback here from Ms. D. And yeah, I think this summarizes my thoughts too, Chakisha. Like, just a mess. And Derek says, sorry, just joined. What's the case? So the reason this is in the news is Jimmie Duncan, and that's towards the beginning of this video. It weaves in and out between the broader problem of the shenanigans of expert witnesses and stand-in medical examiners, bite mark science, but really the main case why this was in the news, and I started looking at it today, is the case of Jimmie Duncan, who's on death row, but he's been exonerated and through the appeals courts, and the prosecutors are fighting that appeal. They want the opportunity to try him again, and even the victim's family members are like, no, we think they railroaded him, and we don't want him to be retried. We think that he's innocent. And the prosecutors aren't even reaching out to us now, even though they reached out back then and tried to get us to lie. So this is really kind of fixated around the story of Jimmie Duncan and the prosecutor's fight to appeal the decision that exonerated him. But it's weaving into the stories of Michael West, Stephen Hayne, and a bunch of other medical examiners and or bite mark expert witnesses that have done really heinous things that I don't see how they can be attributed to incompetence. It seems pretty intentional what we're reading. So now we're just getting the big picture stuff here, Derek, but good to see you. So according to NAME, a single medical examiner should perform no more than 250 autopsies per year. At 325, the group considers a doctor to have phase 2 deficiency. This is cool because it seems like they've actually done the math. Like, things like burnout, you start to lose productivity when you do too much, or like muscle training. If you just continuously train, that can actually start to be detrimental at a certain point. So it's cool that they have characterizations of efficiency and integrity of work in this space. So by the time you're doing 325 and getting into phase 2 deficiency, it will not accredit a practice regardless of any other criteria. Hayne has repeatedly testified under oath that he performs more than 1,500 autopsies per year, a staggering number that dwarfs even the output of the prolific Dr. Erdmann. That's more than 4 per day, every day of the year, for the 20 years Hayne's been in Mississippi. In a 2002 deposition, Hayne put the estimate at 1,800. Guys, that's like 5 a day. What's more, for most of his career, Hayne, and then he's testifying. He's also testifying at trials. So, like, this isn't just he's in a room all day like a factory line doing autopsies. He's also testifying at certain trials, which takes time. What's more, for most of his career, Hayne has held jobs as medical director of the Rankin Medical Center, a post he left last summer. This is again 2007. And as director of the Renal Lab, a kidney and dialysis research center. These jobs, he has testified, would take up about 55 hours per week of his time. Hours not spent performing the 30 to 35 autopsies he says he does each week. Guys, a typical autopsy should take 2 to 3 hours, but sometimes takes an entire day, depending on the condition of the body and the cause of death. And remember, he was doing forensic autopsies, I think we heard. Maybe that was about a different examiner. But if these are supposed to be forensics, I would imagine that if it's meant to determine whether or not a crime occurred and you're rushing through them, that's even more significant than just was there a pathogen in play. Hayne said in depositions that he also testifies 2 to 3 to 4 times per week, all across Mississippi, which means he's got to drive around to different courthouses and occasionally in Louisiana. So he's got to commute to a different state to testify. How does you guys know Harry Potter and Hermione? She had that like time travel necklace. So she was the nerd, right? So she wanted to take all these classes. So she booked herself for courses that ran at the same exact time of the day. And she would use this like time turner to make herself be able to attend both classes. Does this guy have one of those? Shout out to FFS. Missing you over here. Hope you're doing well. Happy 4th. I feel like you're a fellow Floridian, so you've probably had fireworks in your backyard and your neighbors for the last week and a half. You know what? Side story. Last night, leading up to midnight, we got these like one-off, like the fireworks. Like they just kept puttering. Every few minutes, there'd be a firework puttering. And I'm like, okay, I've got to deal with this at midnight. They're probably going to, it's the 4th at midnight and they're going to let off this big grand thing. And they're just testing one out here or there. I'm waiting and I'm waiting. We get to midnight and it's dead silent. But they were like pew-pewing one firework at a time. Like, and then they never did anything. And then a few minutes later, they're doing the one at a time thing again. So very disappointed in my neighbors for that. Yeah, Derek, that is a lot of bodies. Yeah, YP Come Sheet, good to see you. If you are doing 5 autopsies a day, you're taking some shortcut somewhere. Yeah, especially with this context here. You're giving up. He's claiming he's done 55 hours per week of his time, so he's lying somewhere. He's either cutting corners or lying about his experience and what he's busy doing, or both. Because it's just not possible otherwise. Maybe he has a twin brother. Oh, I hope not. At the very least, I hope there's only one Mr. Hayne. So, how does he find the time? Where does he find the time? In his testimony, Hayne has claimed he, quote, commonly works 18 to 20 hours per day. I would not want someone that you get unreliable. He says he doesn't take vacations and works every weekend and every holiday. Until recently, Hayne performed most of his autopsies not at the state lab in Jackson, but at Mississippi Mortuary Services, a funeral home owned by Jimmie Roberts, the longtime Rankin County coroner. Hayne and a few trusted assistants do most of his autopsies late at night, and the operation has a gruesome reputation. People who have visited Hayne's practice during an autopsy session have described seeing as many as 15 bodies opened at once. Oh my God. With Hayne and his assistants smoking cigars and sometimes even eating sandwiches as they go from one body to the next. Critics interviewed for this article, none of them particularly squeamish about autopsies performed under normal conditions, referred to Hayne's operation as a slaughterhouse, a sushi shop, and a sausage factory. Gross. No, I was going to have some sausage later on the grill. Stop it. Guys. This is like poker night. Poker night, and they just got... And then it makes you wonder about things like touch DNA, right? Well, how would DNA from this person get over there? Maybe like this. Maybe this is one of the ways. John is still in the chat. I was thinking the same when I said sandwiches. Oh my goodness. Just hanging out eating sandwiches. And the sausage factory. Because potentially criminals always saying, you don't want to see how the sausage is made. Dwayne Wolf, a doctor... another wolf, guys. Another wolf. A doctor who works for the Harris County Medical Examiner's Office in Houston had occasion to review, what a fun occasion that must have been, to review one of Hayne's autopsies when he was practicing in Alabama. Dr. Hayne's deficiencies are glowingly obvious when you review his work, Wolf says. There were a lot of things done in a substandard way. Harry Bonnell, a medical examiner in private practice in San Diego, who sits on NAME's ethic board, we heard about him in the other article, was asked by a defense attorney to review an autopsy. Oh, I think we heard about him because he's part of Jimmy Duncan's post-conviction team. So he was asked by a defense attorney to review an autopsy Hayne performed in 2003 on a suspected murder victim. Bonnell was floored by Hayne's conclusions. Using unusually strong language, Bonnell said Hayne's conclusions were near total speculation, the quality of the report was pathetic, and Hayne's failure to obtain specimens from the body and perform toxicology reports borders on criminal negligence. Professionally, I think he does too many autopsies, says Winter. Winter? Who's Winter? They just interviewed too many people. They can't keep track of who they're quoting. Way too many of them to do in the manner they should be done. Vincent DeMeo, author of Forensic Pathology, widely considered the profession's guiding textbook, says of Hayne's remarkable annual output, "You can't do it. After 250 forensic autopsies, you start making small mistakes. At 300, you're going to get mental and physical strains on your body. Over 350, and you're talking about major fatigue and major mistakes. That isn't even a quarter of the number of forensic autopsies Hayne has said he performs each year." So here's just a few of the ugly results. The case of the forgotten fingernails. This sounds like, oh my God, what was it? Goosebumps. This sounds like a Goosebumps story. Oh goodness. Shout out to Goosebumps, that, Animorphs. Those are some great young adult books growing up. And maybe they still are. Maybe they're still popular. I hope they are. In February 2006, Kenneth Chandler of Columbus, Mississippi, was the victim of a gruesome homicide, stabbed to death in his home. The body was sent to Hayne for an autopsy. Now, what did we hear earlier? If you want to get the prosecution, if you want to get what you're looking for, you send the body to Hayne. So the body was sent to Hayne for an autopsy. According to sources at the Columbus Police Department, Hayne forgot to take scrapings from under the victim's fingernails. James Starrs, a well-respected author of several books on forensic pathology and a professor of law and forensics at George Washington University, says such an oversight is inexcusable. You do scrapings in every autopsy, says Starrs, especially in a homicide, and especially in a case, such as this one, where the victim has defensive wounds. Yeah, I think that's... I'm not a forensic pathologist, but I think I can agree. I would assume if you're not doing it for every autopsy, you'd at least do it for a case, a potential murder victim. You're gonna look for these things every time. So why aren't we? Columbus police personnel had to rush to the funeral home to obtain the scrapings before the body was embalmed. We've got another one. The case of the... Why are they naming these all like Hardy Boys books? The case, Nancy Drew, the case of the strangled skeleton. In 1999, the body of Prentice, Mississippi resident Tanya Ward was found in a wooden area, completely skeletonized from the waist up due to decomposition in wild animals. At the trial of the accused, and I think this was a major case, wasn't it? Maybe her name's just sounding familiar. I think this was a major, like a high-profile case. So, at the trial of the accused killer, Hayne testified that Ward's remains showed signs that were consistent with strangulation, a conclusion other medical examiners say could not be reached unless there was muscle tissue to examine. So she's already decomposing. After the local public defender subjected Hayne to a vigorous cross-examination, the defendant was acquitted. So shout out to this public defender for calling out the BS. And it's crazy that, this little paragraph gives you the context you need. She's skeletonized from the waist up due to decomposition in wild animals. So it's bone. We've got bone. We don't have soft tissue left. But we're somehow making testimony about muscle examination in the neck to show, yeah, she was strangled to death. So shout out to this public defender for catching it. It's amazing that this can be, the beginning and the end can be put into this little paragraph here. All right, before we do these headlines, oh man. Let me hop over here to shout out to Casey, dog. Good to see you. Good to see you. I'm always thinking of Kansas City style, Memphis style. How am I going to do my barbecuing today? Maybe I got to go with KC style. And there's my answer. Who's winter? Where is winter? KC Doc says, you know what? Winter is here. So big thank you for that, because I don't know where that one came from. Yeah, YP Cum Sheiks is not the sausage on the ground cat. Yeah, no. Too tall, good to see you. I like the chat bubble. John says, this makes me never want a mortician to touch me. Yeah, or stand around you smoking cigars with like 14 other, like, are we all just supposed to be homies with each other? Me as a corpse, I'm now homies with the other 14 people, the other 14 corpses. We're all just sitting there all exposed and open while people smoke cigars over us. Very, very, very respectful of the dead. And then FFS here, let's see. We got one snipe or sprinkle from FFS. We got 2 sprinkles. We got 3 sprinkles. This is. I'm not even gonna make a joke about it. I was gonna go after the number of things in the autopsy room. I'm not gonna go there though. But big thank you here to FFS making 3 people green. And don't forget, Cash Money Cass. I don't know if she's still hanging out in here, but she did have her wedding. She is officially Mrs. Cash Money Cass. We've got the green slime panya glasses in the channel member emojis. So if you just turned green, make sure you use one of those. Big thank you to FFS and shout out to Mrs. Cash Money Cass. And let's see, let's get to this next one. This one is called The Case of the Naturally Bludgeoned Woman. In 1998, this is like naturally bludgeoned. Like, did a coconut fall in her head? After a woman's body was found in the Mississippi Delta, Hayne concluded she had expired of natural causes. Because the woman was a resident of Alabama, that state's medical examiner asked Stephen Pustelnik, at the time a state medical examiner in Birmingham, to perform a second autopsy. So is Hayne getting one wrong in the other way? Because this is different. Pustelnik found that Hayne hadn't even emptied the pockets of the woman's robe. Moreover, many of the internal organs Hayne claimed to have examined in the autopsy report hadn't been touched. The woman was later determined to have died from a blow to the head. So there you go. There you have someone that is not getting justice because the autopsy wasn't done. Pustelnik, who declined to comment more broadly on Hayne's practices, says that in this case, Hayne's autopsy was, quote, near complete malpractice. Starr says such oversights are glaring. Emptying the pockets of personal effects, taking pictures of everything on the deceased person, these are really standard procedures, Starr says. It's a quintessential part of a standard autopsy. Because there's more, guys. There's more stories. The case of the $3,700 edit. Twice in 1997, years after he'd performed the autopsies, Hayne changed his diagnosis in 2 infant deaths from sudden infant death syndrome, SIDS, to asphyxiation. So he's changing 2 things that looked like not a crime to a crime. The abrupt change came after Hayne had been contacted by plaintiff's attorneys, so we're getting civil suits. Plaintiff's attorneys who wanted him to testify on their behalf in a suit against the manufacturer of an allegedly defective infant rocker. How much are you getting paid to testify today? And sometimes that question's kind of like, you got to ask it, right? Obviously, you're being paid to testify. But it's not damning that an expert time gets paid for the work they do, right? People should get paid for the work they do. But in situations where the integrity of the work's under question, that payment is a reason why you would do your work with less than the basic expectations of ethics, of integrity, of following standard operating procedures. Here's one of those very glaring examples. Two of them. So he gets contacted. This is the change, right? We have this change from, it was just SIDS, and now it's something, it was asphyxiation. After a plaintiff's attorney who wanted him to testify that a manufacturer was selling a defective infant rocker. Questioned about the cases in subsequent depositions, Hayne testified that he had changed his diagnoses after reviewing medical literature, but without re-examining the bodies. In one of the cases, Hayne's practice billed the plaintiff's attorneys $37,000 after making the alteration. For Stars, such an abrupt change in diagnosis is troublesome. SIDS, Stars says, is a catch-all diagnosis, often used in infant deaths where other symptoms are lacking. He's going where I'm going. It would be very difficult to change from SIDS to asphyxiation. Right, because if you're choked, if you die because of loss of oxygen, there's the outward physical signs, and then there's signs that your cause of death would be the lack of oxygen flow. So if this stuff is lacking, how do we make this switch? What takes us here? So Stars explains for us, he's the expert. He says, because the latter is a more specific diagnosis, one that would require the presence of symptoms Hayne should have noticed during the original autopsies. So there you go. That is the case of the $37,000 edit. And then some, right? Because this was 2 cases, but we only have the billable amount in the one. Big shout out to Peter Ortiz. I thought about you with my firework boom emojis today. Hope you're doing well. The doctor needs a stiff drink. No. They probably did. They probably also drank. Yeah, I agree. FFS says, I think that was the original problem. Yes. And hey, good to see you, Dark Child. Hope you're doing well. And yes, Trakisha says she looked gorgeous talking about Mrs. Cash Money Cass. She absolutely looked gorgeous. It was super, super beautiful. Like the way she had her hair done and the dress. She posted pictures over on X, you guys. So make sure you follow her over there. Not just for the wedding pictures, but because she always does those like TikTok style videos, doing impressions of some of our most favorite characters from different trials. So now we're moving on. I think this is the end of these little mini stories. They're gonna write a whole series on Dr. Haynes's cases on death row. So Haynes' testimony, this is bringing us full circle to why we are here doing this stream today. Haynes' testimony hasn't just sent people to prison. In more than one case, it has helped someone land on death row. Consider Jeffrey Havard. So we read about him earlier. He was convicted in the 2002 killing of his then-girlfriend's 6-month-old daughter. Havard claims he was bathing the child when she slipped from his hands and hit her head on the toilet. But Hayne testified at Havard's trial that bruises, scratches, and cranial bleeding indicated a case of shaken baby syndrome. Hayne also testified that the child's anus was dilated, indicating sexual abuse. And if they don't get to this, the other article we read brought in, including Dr. Michael Baden, a ton of experts that are like, look, dilation is natural in children and adults after death because the muscles relax postmortem. The DNA evidence was inconclusive. Havard's DNA was not found on the baby, but both his DNA and hers were found on a sheet from the bed where she had gone to sleep that night, which was also the bed Havard shared with his girlfriend. Because there were no witnesses to the incident, the evidence of sexual abuse was key to securing Havard's conviction and death sentence. The charge was murder in the commission of sexual battery. Havard, who had no money, was assigned a public defender. His lawyer was suspicious of Haynes' conclusions and at trial asked the court for funds to hire an independent pathologist to review Haynes' findings. The judge refused, ruling that Hayne, the prosecution's witness, was qualified and sufficient. So, and then just think about all the things we read in this article alone. After Havard, the guy that's removing ovaries that says he removed an ovaries from a male body, a male corpse. The guy who reported the weight of the gallbladder, that the family is like, how could you weigh that? He had that removed surgically years ago. Yeah. So nope, you can't bring in an expert to challenge him. He's qualified, he's sufficient, denied. After Havard was convicted, attorneys from Mississippi's Post-Conviction Relief Office, which represents indigent defendants in their appeals, were able to get James Lauridsen, Alabama's former state medical examiner, to review Haynes' work in the Havard case. According to an affidavit he filed with the Mississippi Supreme Court in 2004, Lauridsen found significant problems with Haynes' testimony. Nobody's surprised. Most notably, factors not related to abuse, like rigor mortis, can often cause the anus to dilate after death. In February 2006, the Mississippi State Supreme Court nevertheless upheld Havard's conviction. It refused even to consider Lauridsen's review of Hayne's work, ruling that any expert testimony refuting Hayne's conclusions had to have been introduced at trial. Havard's attorney tried to do just that, of course, but the trial judge denied him the necessary money. What a catch-22. You fight to get this, and we've looked at appeals where this was the case. Well, we tried to introduce something at trial. Well, you should have introduced that at trial, but we're not going to reverse. You should have introduced it then. Well, I tried. You're damned if you do, damned if you don't. In fact, maybe he would have been better off if he didn't even try, and they could have just said, "Oh, it was ineffective assistance of counsel because they didn't try." But we're not going to blame the judge. We don't want to scold the judge for making a decision outside of the reasonable bounds of his discretion to deny this request. Maybe this would have been better off if we could have thrown trial counsel under the bus. So as unfair as it sounds, it isn't all out of the ordinary. It sure isn't. Indigent defendants, by definition, can't afford to hire their own experts. This is one reason it's important that state medical examiners and forensic experts retain their independence from prosecutors' offices. Yeah, and not become known, where if you want to get the results you want, you bring the body to Haynes. Post-conviction relief offices, which are usually established at the state level and are better funded, sometimes have the money to hire independent experts, but these offices typically don't take a case until it's already in the appeals phase. At that point, courts are extremely reluctant to consider new evidence, particularly expert testimony. The Harvard case is now entering a second round of appeal. The Havard case is now entering a second round of appeals. Lauridsen and Havard's lawyers wouldn't discuss the case for this article, citing the ongoing appeal. Though Lauridsen did call it a miscarriage of justice. But according to the court's clerk, at press time, the case was being delayed because Hayne wouldn't turn his autopsy records over to Havard's defense team for review. Now, let me Google this because this article is from 2007. Havard appeal. Let's see if there's like an update on that. Or did we get an update from the first article? I think we got a conclusion on this in the first one. Let me see. See. Oh, that was Michael Baden. That was Dr. Michael Baden. So this is the one where, after examining the case, Dr. Michael Baden concluded that Chloe Britt, the baby's injuries, were consistent with her being accidentally dropped and that she wasn't SA'd. And now the original pathologists agree that they don't think it was. Let's see. And then it says at least 37 people. Maybe his name is in here. So let's see if we can get an update quick. Maybe this is a fuller list. Okay, I don't think it's giving us results. So maybe his case is still ongoing at this point in time, or maybe his appeal was denied. That was just a quick search. I don't know conclusively. But let's see, we were over here. But yeah, so back in 2007, they wanted Haynes' reports for this appeal, the second round of appeals. And Haynes like, no, I don't want to turn those over. Haynes' qualifications. According to his curriculum vitae, his CV, shout out to Shannon Burgess, Hayne attended medical school at Brown University from 1974 to 1976 and completed his medical internship in 1976 at the Letterman Army Medical Center in San Francisco. After practicing medicine in California, Kentucky, and Alabama, he came to Mississippi in 1987. He began doing autopsies for the state's county coroners, elected officials who are not necessarily physicians, shortly thereafter. Hayne briefly served as Mississippi's interim state medical examiner in 1987 and 88, but was forced to step down because he wasn't qualified for the job. Okay, so this is different than Shannon Burgess. They actually said, you know what? No, you're not actually, you don't have these credentials. Under Mississippi law, the state medical examiner must be certified in forensic pathology by the American Board of Pathology, the standard certifying organization in the profession. Though Hayne routinely testifies under oath that he is, quote, board certified in, quote, forensic pathology, he isn't. At least as the phrase is understood by most of his peers. Instead, Hayne says he's certified by other organizations that are considerably less reputable. When you say you're certified, it means the American Board of Pathology, says Joseph Prallo, NAME's president. Told that Hayne routinely testifies that he is certified even though he never passed the American Board of Pathology exam, Prallo replies, "That is very disturbing to me. There's definitely a problem with that." Hayne has testified that he did attempt to take the American Board of Pathology certification test in the 1980s, but failed the exam after walking out in the middle of it. He said the questions were absurd. What? Oh my god, you guys. This is almost on the same level as Michael West, the bite mark expert that made his own scientific process, a type of test that couldn't be replicated by any but himself. He called it the West phenomenon that we read about earlier in this stream. Nobody else can do this but me. I'm the only one that can do this West phenomenon where I put on a black light and I wear yellow goggles and I can see all the marks and lacerations on a body. Nobody else can replicate this. That was Michael West, bite mark expert we talked about earlier. Now we've got this guy who's like, screw this exam. The questions are absurd. I know better. Like, these guys just both have such levels of audacity. Which is different if you're like, you own a restaurant and want to say you have the greatest food ever. Like, all right, you're not putting someone in behind bars because of your pompousness. But here in this position, that's crazy. And what do I got? You guys are over here. I see. What do we got? Hey, Angie, good to see you. Charles White did a snitching video. No self-snitching. No self-snitching, chat. Oh, or you mean snitching on Woody? Yeah, there's a whole side story going on in the chat here. But yeah, here with Haynes, another Burgess. Another Burgess. And meanwhile, Burgess, you know, maybe his typical testimony or work is like civil cases, insurance. I'm not saying that that's insignificant, but in the Karen Reed case, that was involving, you know, a murder charge. Here, though, with Hayne, whatever Hayne is doing is just like, Hayne is heinous. Whatever he's doing with his heinous work is implicating hundreds, maybe approaching thousands of people in things that they potentially did not do, and that there wouldn't really be evidence to support a prosecution for, would it not be for Hayne himself. So anyway, he walks out of this exam. He doesn't get this certification, but he's claiming he's certified. And so he can't serve as a state medical examiner because he failed the certification exam. But he spent the last 20 years doing most of the state's forensic autopsies anyway. One of the groups Hayne lists on his CV, the American Academy of Forensic Examiners, doesn't seem to exist. There you go, Nicola, another Burgess. Should we Google this? American Academy. What is this, a forensic film exam? Did he submit Michael West's video here? Let's see. Okay, there is a American Academy of Forensic Sciences, which is not the same. American College of Forensic Examiners Institute. Yeah, no, it just sounds like, you know, you came up with something that sounds good. So it doesn't seem to exist. Some forensic experts interviewed for this article say it's an alternate name for the American College of Forensic Examiners. So But hold on. That, though it's real, has been criticized by legal experts as a mail order outfit where only the necessary qualification is a check. So just like being a super lawyer, right? Um, in the real estate space, because I'm keyworded, a lot of my profiles, there's these magazines like Top Realtor Magazine, Top Agent Magazine. And you just get these LinkedIn messages from people that are scraping the keywords and saying, hey, you've been nominated. You can, for $500, you'll be named as a top 30 realtor in your market. And it's all just a mail order outfit, just like this. So, not really anything except something that you paid to have the title of. Consistent with that reputation, Hayne has testified that the American Academy of Forensic Examiners, quote, grandfathered him into a certification without an exam. What? Why does this guy never want to take an exam? In the past, Hayne has listed another certifying group, the American Academy of Neurological and Orthopedic Surgeons. It no longer offers specialty certifications in forensic pathology. The forensic experts I interviewed for this article had never even heard of it. The doctor the group sent to proctor Hayne's exam for the organization has since been indicted on felony charges and no longer practices in medicine. They went and looked through everything in this guy's CV letter. An absence of oversight. In Mississippi, as in many states, elected county coroners are in charge of death investigations. Traditionally, such systems include a state medical examiner's office to make sure the coroners are referring bodies to reputable, board-certified forensic pathologists. But while Mississippi law calls for a board-certified state medical examiner to oversee the process, the office has been vacant since 1995. This is a 2007 article. The legislature refuses to fund it. Autopsy fees come from individual counties, not the state treasury. So there's no one at the state level assessing the quality of autopsies done in Mississippi. And remember, we have Hayne saying, like, I do 30 to 35 autopsies a week while working 55 hours at a dialysis center and testifying 2 to 3 times a week in trials and traveling all over to different counties in Mississippi as well as Louisiana to work on cases. So, it's not like his work is restricted to this one county because he's a well-traveled man. With so little oversight, underqualified Mississippi coroners and politically driven district attorneys can shop autopsies and the fees that come with them to their favorite medical examiners, such as Hayne. Hayne charges about $550 per autopsy. According to several sources, Hayne receives fees for other services, such as drawing fluids or sending tissue to a lab for testing. He then gets $195 per hour for trial preparation and testimony. That's just for state cases. If a county coroner brings a body to him at the request of a plaintiff's attorney or for a private tort action, Hayne has said in depositions he charges $1,500 or more, plus $375 per hour for trial preparation and testimony. Hayne's efficient operation and reliable court appearances have allowed him to dominate the forensic autopsy business in Mississippi. A 1992 internal memo from the state's Department of Public Safety estimated that Hayne performed 80% of all forensic autopsies performed in the state. And again, forensic autopsies is for the determination of did a crime occur. Sources interviewed for this article say Hayne continues to do the vast majority of forensic autopsies in Mississippi. It's a racket, says Sanders, the former Columbus police chief. Most states pay a state medical examiner $100,000, maybe $200,000 per year. Do the math. 1,500 autopsies, and he's said that he's done up to 800 in 1 year. 1,800 per year at $500 to $1,500 a pop. He's making millions. Prosecutors love him because he'll testify to whatever they need him to. This is coming from a former police chief. Meanwhile, the state legislature saves money by not having to fund a full-time state medical examiner, office, and state staff. Hayne's relationship with the Mississippi district attorneys is another cause for concern. As noted above, name standards call for forensic experts to be independent seekers of fact, but that doesn't appear to be the case in Mississippi, where district attorneys expect medical examiners to be part of the prosecution team. In 1994, for example, John T. Kitchens, the district attorney for Rankin and Madison counties, wrote a letter to the state commissioner of public safety, complaining that the state medical examiner at the time, Emily Ward, had, quote, unnecessarily rendered aid to the defense of criminal defendants. They were mad. They were mad. She probably said something like, "Well, I can't conclude that it was a homicide." Shout out to Scorty Bello. Kitchens warned that public officials surrounding the criminal justice system must remain mindful of who they work for. That prosecutors shouldn't have to, quote, bear the extra burden of wondering for which side the state medical examiner is then employed, and that the state examiner should never confer with defense counsel without the consent of the district attorney involved in the case. Defendants, Kitchens argued, can hire their own experts with private or public funding. Hey, but we heard about a case earlier, the Havard case, where we had a public defender say, look, my indigent client, we are very suspicious of the work that Hayne did. Hayne, this name in flashing lights, incompetent, pathetic, doesn't want to take exams. Judge, we want to challenge his work. We need some funding to do this, though, because I'm a public defender and my client is indigent. Nope, judge denies it. But here we have Kitchens, who's pissy. Kitchens is all up whatever, I don't know. Yeah, John T. Kitchens, so it's a he. He's all mad. He's a district attorney for Rankin and Madison. He's writing this letter all mad. And he's like, well, they can hire their own experts with private or public funding, but then the judges aren't allowing it. So, great argument that goes nowhere. In response, the Department of Public Safety sent Ward a memo that essentially agreed with Kitchens' interpretation of the state medical examiner's proper loyalties. So there you go. You have a district attorney who cries and we don't even know what it is, but he's just alleging that Emily Ward, a medical examiner, unnecessarily rendered aid. Rendered aid reminds me of like somebody's dying and you help them try to breathe or you suppress their wound, you put pressure on. Rendered aid could just mean they answered a question on cross-examination and gave an answer that was honest, but the district attorney didn't like the answer. This whole letter could just be because they didn't like something that came out on cross. And then you have a judge, you have judges denying the solution that Kitchens suggested, and then you have the Department of Public Safety. Just, yeah, we agree. We agree. We agree with the crying. At several points during the last 30 years, Mississippi's coroners and prosecutors have attempted to make the state medical examiner report directly to the state attorney general. George Washington University Stars says the sentiment that experts work for the prosecution, though common, is inconsistent with the medical examiner's duty to impartially investigate a death. Contrary to Kitchens, and this is why, you guys, when we looked at the Megan Jackson trial a few weeks ago, that was why the case caught my interest, because with Megan Jackson, she was a body transporter and she was having an affair with the coroner. So to me, it was this relationship tainted any chance of impartiality. And of course, they're accused of, Megan Jackson was convicted of actually doing the killing. The coroner, Christopher Dontel, took a plea and he admitted that he was an accessory after the fact by helping to dispose of the body and conceal the crime that Megan had committed. Right? But that's why I thought it was so interesting, because you can't have this is your coroner. I have questions. And it seems like maybe their behavior was insulated to that one particular incident, but how do you know? Contrary to Kitchens' apparent assumption, most criminal defendants can't hire their own experts, because most criminal defendants don't have the money to do so. And public defenders and criminal defense attorneys with heavy caseloads don't always have the time to examine the credentials of every expert witness for the prosecution. In the case of Hayne, who has been certified as an expert by Mississippi's courts thousands of times over the years, such an exercise seems futile. Moreover, trial courts aren't always willing to allocate public funds for independent defense experts. With a few exceptions, the most vigorous examinations of Hayne have come during depositions in civil cases, medical malpractice suits, for example, where the opposing side could afford adequate representation and could hire independent experts to review his work. That's the theme of this: freedom, innocence, wrongful incarceration. For us to get to the problems, to take a situation where the person fighting the fight has money is a huge problem. Because that means you have to have the perfect recipe to uncover the wrongful practices. You have to have standing to bring a civil case. right? So if someone doesn't have standing to bring a case against somebody, they can't just go and say, I'm going to sue somebody because they did something wrong in another trial. I can write a letter to the Department of Public Safety and ask them to do something, but we're seeing that gets ignored. I can write to the Attorney General. They would have standing, but we've seen that the letters are getting ignored. So we have to have standing to even bring a civil claim. When you bring a civil claim, you got to have money. You got to have money or an attorney who's willing to take a case on contingency. So it's a huge, huge hurdle to even be in a position where you'd be able to call something like this out. And yet on the criminal defense side, the flip side of not being able to call that out is you're losing your freedom to a wrongful conviction and whatever sentence comes along with it. So let's see. The Mississippi medical examiner system doesn't exist, except in name only, concludes DeMeo, the forensic expert and textbook author. This man provides a service and at a discount. You're not going to get a change in a system where all the people in power are happy. It's a good quote. Frustrated reformers. Those who have tried to effect changes anyway have met considerable resistance. Lloyd White served as state medical examiner from 1989 to 1993 under Democratic Governor Ray Mabus. He is now a state medical examiner in Tarrant County, Texas. He performed the autopsy on the slain Tejano pop star Selena, so that's a familiar name. Among other changes, White tried to require minimal competence tests. So, just even the bare minimum. Please don't walk out, Hayne. It's just a bare minimum competence test. Don't walk out this time. And continuing training for Mississippi's county coroners. Most of his suggestions are officially still part of the state's regulations, but they're ignored. White was especially concerned about the cozy relationships between coroners, district attorneys, and private medical examiners like Hayne, relationships that the ad hoc autopsy system seemed to encourage. Yeah, they're standing around smoking cigars. There's a tendency to slant things to favor the people you're working for, White says. The politics and power could sometimes run roughshod over people's civil rights. Julia James, now retired, worked for 27 years in the state's crime lab and served as the lab's interim director from 2004 to 2005. A prosecutor would sometimes come back to us on a case and say something like, "Can't you go further?" Or, "Are you sure it didn't happen this way?" Of course, the analysts I work with always try to maintain their neutrality. And remember, we've got the Karen Reed case where, which was the officer that went and did was Scorty Bello? Was that Tully? Or is that Buchanan? Well, whatever the case is, you've got this guy going in and trying to feed details of possibly context that could steer what a medical examiner was looking for. White left his position in 1992 with the election of a new governor, but he went out with a bang. Oh, God. Before leaving, we need some fireworks in the chat. How did White go out? Before leaving, he wrote a blistering public letter to Charles Tisdale, editor and publisher of the Jackson Advocate, a hard-hitting black paper, sometimes called the most firebomb newspaper in America. I love this for the 4th of July. Tisdale's paper had been doggedly pursuing a series of suspicious suicides in Mississippi jails that many civil rights leaders believed to be homicides. White himself suspected the deaths were really suicides, but he didn't believe they were properly investigated. In particular, he was troubled that the bodies were being sent to examiners like Hayne, who, experience taught him, couldn't be trusted to give an unbiased conclusion. White's letter called Hayne out by name, noting that despite his lack of credentials and poor practices, Hayne continues to autopsy jail and prison deaths, as well as persons killed by police or sheriff's deputies, and to generate hundreds of thousands of dollars in personal income as a result of his extremely cozy relations with state employees and officials. So it's not just give me a body and I'll find you the crime. Give me the body and I'll really give you the outcome that you want. If you want there to be a crime, I'll find a crime. If you don't want there to be a crime, I won't find a crime. Or if it's a civil case and I'll get $37,000 to testify, I'll do the upfront work, $1,500 for the exam and $375 an hour, and make my $37K for your private case. I'll change the cause of death from SIDS to asphyxiation. So, just crazy. Just crazy. White also cited a case in which he had performed an autopsy on a woman who'd been found dead in her bathtub. White concluded it wasn't immediately possible to determine a cause of death. He needed to wait for the results of toxicology and microscopic tests. According to White's letter, he soon received a phone call from Hayne, who told him the body had been taken to Hayne's office for a second examination at the request of Forrest Allgood, the district attorney for Clay, Lowndes, and Nixupi, and oh my god, Octubeha counties. They're trying to get me, chat. Although White was the state medical examiner at the time, he said the second autopsy was performed surreptitiously without my knowledge or permission. Allgood already had a suspect he wanted to charge with the crime, White said, and he was afraid my autopsy wouldn't provide him with the evidence he needed. Allgood's office did not respond to requests for an interview. Oh, that would have been good. According to White, but of course they didn't respond. According to White, Hayne told him he had concluded that the woman was strangled. White said Hayne then suggested it would be in White's best interest to issue a report agreeing with him. How if you... White's successor, the last person to fill the job of Mississippi State's medical examiner, was Emily Ward. We heard about her. The one that rendered aid to the defense, the pesky defense team at trial. Appointed in 1993 by Republican Governor Kirk Fordice. Her tenure was even more raucous than White's. One of Ward's first goals was to get the state medical examiner's office accredited by name. And remember, the reason they're going into this in the article is we've established that Hayne is very suspect, but we're getting into the seems to be a conscious choice by state bodies to work with people like Hayne and oust people, keep people at arm's length that might have more integrity and skill and competence behind their work. All right, so we have this White, we don't really have an official state medical examiner at the time this was written in 2007, after Emily Ward was last appointed. But her tenure, the medical examiner that rendered aid to the defense, was problematic. Maybe why is that? So her first goals were to get the state medical examiner's office accredited by name. We want to actually live up to certain standards. Ward also proposed that the state office, which handled less than 10% of the forensic autopsies performed in Mississippi, take on more of the burden. So let's stop outsourcing 80% of these things at $500 a pop to Hayne. It was a sensible move. The fees the counties were paying to private practitioners like Hayne could instead go to the state medical examiner's general fund, making the office less dependent on the inadequate budget provided by the state legislature. And it would also mean more autopsies would be performed by independent, board-certified forensic pathologists. This proposal rankled Hayne and the county coroners, who stood to lose both power and income under the plan. Dr. Ward came in here and tried to clean up the system, says Andre DeGroy, who directs Mississippi's Office of Capital Defense Counsel, the public defender office for death penalty cases. Hayne and the coroners got together and chased her out. Two coroner, yeah, and again, this image, guys. I keep having this image of them standing around and smoking cigars while there's 14, 15 open corpses in this funeral home they all used to work at. Again, doesn't sound like something you do with people you're not friends with. Two coroners with strong ties to Hayne emerged as Ward's most vocal critics. One was Jimmie Roberts, the owner of the funeral home where, until recently, Hayne did most of his autopsies. So Jimmie Roberts doesn't like Emily Ward, the guy that ran the building where they're all standing around with the cigars. The other was Michael West of Forest County, a dentist. We know Michael West, a dentist who is frequently present at Hayne's autopsies, whom Hayne has cited in depositions as a reference for his credibility, and who has collaborated with him on presentations and journal articles. Just two peas in a pod. West, who declined to be interviewed for this article, of course, has his own credibility problems. Oh my god, we're going to get the West phenomenon again. He claims to have perfected, guys, if you missed this earlier, I still think this is the craziest part of the stream. He claims to have perfected a method of identifying bite marks using laser light and orange goggles that he modestly calls the West phenomenon. This is so Kanye coded. He's said his error rate in bite mark analysis is something less than the error rate of my Savior Jesus Christ. This can't be right. Hold on. He claims to have perfected a method of identifying bite marks using laser light and orange goggles that he modestly calls the West phenomenon. He has said his error rate in bite mark analysis is something less than the error rate of my Savior Jesus Christ. What? Why? Oh, the audacity. And has compared his bite mark virtuosity with the musical talent of Itzhak Perlman. West once claimed he could trace the bite marks in a half-eaten bologna sandwich at a crime scene to a suspect. After exposés of West appeared on 60 Minutes and in Newsweek and the National Law Journal, prosecutors in Mississippi largely stopped using him, although there are still people in prison because of his testimony. And I think I remember this 60 Minutes episode. I don't think I read what was said here, but I think I remember this specific 60 Minutes episode years and years and years ago. Or maybe watching it somewhat more recently when it was reshared. 60 Minutes has had a lot of great exposés. Yeah, what are we doing? Oh my gosh. My error rate is less than Jesus Christ's error rate. What? First of all, the foundational argument to this would also be like, Jesus Christ does bite mark analysis, or Jesus Christ doesn't make mistakes and I do something less than 0. So neither direction, the statement makes sense in neither direction. Yeah, what mental hospital did West come from? The West Wing. The West Wing. This is crazy. Yeah, Mookie Mookie. This is the vibe I got too. They were in there smoking like mob workers. And then you've got this coroner who owns the funeral home owner coming out and trying to align to oust the woman who comes in and says, we should adopt standard practices. And they're like, we got to get rid of her. YP come chic, that's just crazy. Yeah, that's just crazy. Oh my goodness. And Amanda, I don't know if you're shouting out to our honorable FFS in the chat or if you're saying FFS about the content, but I'm down for both. I am down for both. Oh my goodness. And big shout out, FFS is out here sniping. We had the 3, I'm not going to say, we'll do cigars. 3 cigars being passed around to us here, the cat mob in the chat. We're hanging out with our sandwiches and our cigars. Another one, we got 4, we got 5, we got 6, we got 7, we got 8. I love the number 8. There you go. So big shout out, lots of FFSs in the chat to show appreciation for FFS and to comment on what we're reading. It's like you can use it both ways. Like, this is just crazy. Yeah, he thinks he's a god. And, like, that's really disturbing when the work that he's doing with the self-touting that he's less prone to making an error than Jesus Christ, when his work is directly deciding a death that already happened, but that decision is being used to potentially put somebody on death row. This is very much like, the concept of, a lot of people for religious reasons don't agree with the death penalty because they feel like that's only God's decision to make. And in a really disturbing way, the work that he's doing, this is the audacity. That's the level that West is embracing. Okay, and Amanda says the FFS was for the gifted memberships. So I figured, but honestly, FFS to me applies as a viable reaction to what we're reading here about Mr. West. It was West who circulated a petition. So it starts from West, a petition among the state's county coroners calling for Ward's resignation. 42 of the state's 82 coroners signed the document. which accused Ward of failing to support the coroners, diminishing their authority, improperly assisting defense counsel in criminal cases, and attempting to establish a political power base. West told the Jackson Clarion Ledger in 1995 that the state's Department of Public Safety had, quote, never been able to keep this woman under control. The Clarion Ledger contacted 30 of the 42 signatories to West's petition and learned that most of them sent their autopsies to Hayne. So again, this is all in this article, this write-up we're in the part of this where they're saying it's not just Hayne as a rogue actor. It's the other state agencies and others in different positions that also benefited from what Hayne was doing. There was a power structure here that went beyond Hayne and West that protected Hayne and West and other similar things. So the paper also found that more than half of the signatories repeated hearsay about Ward they heard from other coroners. So maybe like this, they've never been able to keep this woman under control. And a bunch of people standing around with cigars like, yeah, and could cite no personal grievances against her. The paper concluded that the petition was the result of a power struggle between Hayne and Ward. Not all of Mississippi's coroners agreed with West's assessment of Ward. One told the paper that the petition was baseless and looked like a group of fifth graders had written it. Another lamented that a small group of individuals, for whatever reason, for personal gain or personal ego. Speaking of personal ego, I mean, I think we have that. I think this is objectively an ego-driven person here when we're speaking of West. But for personal gain or personal ego, have continued to badger Dr. Ward. Mrs. Dr. Ward, not Mr. Qualified medical examiners outside of Mississippi seem to agree. Jamie Downs, who served on NAME's board of directors and now practices in Georgia. Is there a doctor with integrity? Is there a medical examiner with integrity helping out in Georgia? That's good to hear. Hired Ward to work for him when he was Alabama state medical examiner. We knew what happened in Mississippi, Downs said, referring to Ward's experience in Jackson. And I'll just say that hiring Dr. Ward was a no-brainer. She's a well-qualified, competent medical examiner, and that alone puts her in a completely different league than Dr. Hayne. So shout out, that's good to hear. I mean, I'm confident taking what we're reading to agree that it's more likely than not that Emily Ward was trying to act with integrity. She was promoting standards of practice, standard operating procedures, and it seems like she was ousted. So I have appreciation for this guy saying, look, it's crazy that they fired her. Of course, we grabbed her up. We were happy to hire her. Ward resigned her position in Mississippi in June 1995. The office has been vacant ever since. So this is 2007. Let's see. And this is I think they're winding down and rounding out their big picture expose here of expert witnesses and the back and forth role between investigations and the start of a prosecution and what plays out in the courtroom of these expert witnesses, these very credible and high integrity expert witnesses. Battered but not yet beaten. When the Mississippi Supreme Court threw out Hayne's testimony in the Tyler Edmonds case. So Tyler Edmonds case is the one again with he was 13 at the time, and it was alleged that he was holding the gun at the same time as his sister when the sister's husband was shot and killed. I can't rule out that only one person was holding the gun. When the Mississippi Supreme Court threw out Hayne's testimony in the Tyler Edmonds case, it was an act long overdue, but the court didn't go nearly far enough. In a concurring opinion, Justice Oliver Diaz wrote that there are serious concerns over Dr. Hayne's qualifications to provide expert testimony. Noting Hayne's troublingly high number of autopsies and his lack of certification, Diaz concluded that the court should not qualify Dr. Hayne as an expert witness in forensic pathology. Oh my God, imagine being the next defense attorney when Haynes was on the witness list for the prosecution and this decision just came down. Oh my God, what a good day for that defense attorney. Your Honor, I have a motion. That understates what's needed. A comprehensive review of every case in which Hayne has ever testified. The sort of review that has been conducted following other forensic expert scandals across the country. Now, this was written in 2007, and the first article we looked at, we have like 10 plus convictions have been overturned, but the article that we first read that was published yesterday stated that there were still hundreds and hundreds of cases that haven't even been looked at, right? They've only really gone through like a dozen. But this, what we're reading on screen, is from 2007 calling for that action, and we've still only gotten through a dozen cases. Despite Diaz's view, the majority in Edmonds upheld Hayne's continued good standing. Uh-oh. Shout out to the other justices as a certified forensic pathology expert in Mississippi. So the defense could raise their motion, but the prosecutors will say, no, the other justices said he's fine. He makes less mistakes than Jesus Christ. That means Hayne will continue his marathon all-night autopsy sessions. District attorneys will continue to send him bodies, knowing they can count on a supportive diagnosis. They will render the aid in their favor. The state medical examiner's office will remain vacant, and Hayne's testimony will continue to put people in prison, even on death row. The problems with forensic testimony extend beyond Mississippi. In March, Joseph Capra, a frequent prosecution witness in Maryland state courts and in federal courts on ballistic matters, and I think I know that name, but this is older. So has he come into question? So he's frequently testified as a prosecution witness for Maryland and in federal courts on ballistic matters. He committed suicide after he was confronted with evidence that he had lied in court about his academic credentials. So I think that's why his name rings a bell. Capra had testified in hundreds of criminal trials before being exposed. Those cases will now be reviewed. To its credit, the Maryland legislature responded by passing one of the most thorough laws in the country, implementing oversight of forensic labs, establishing an independent oversight board, and codifying the standards and best practices recommended by professional organizations. So basically, some and then some of what Emily Ward was advocating for, and they ousted her over. Experts say Mississippi, experts such as DeMayo say Mississippi could solve many of its problems through similar safeguards, such as requiring that any medical examiner certified by its courts meets NAME's minimum standards. A 2004 Chicago Tribune investigation of 200 DNA-based exonerations in Illinois found that more than a quarter involved faulty or fraudulent testimony by expert forensic witnesses. And, you know, Chicago seems like a hotbed of these types of bad prosecutions that relied on bad investigative work and testimony. Hundreds of cases have been reviewed after deficient or fraudulent expert testimony was discovered in the Houston Medical Examiner's Office and in state crime labs in Washington State, Virginia, and Maryland. Even the FBI's crime lab has come under scrutiny. In those cases, the malefactors were identified and efforts were made to undo the damage they caused. Unfortunately, little has changed in Mississippi. So Ken Winter, who often worked with Hayne while running the state crime lab, thinks real change is unlikely unless the system's shortcomings end up hurting someone with political influence. Asked why there haven't been any serious reforms, he replies, "It sounds awful to say this, but it's probably because the right person hasn't been killed yet." And Derek, I think as far as Hayne, I think Hayne is dead. Let me double check. I think we read that Hayne is no longer alive. So Dr. Stephen Hayne, who has since died. So I don't think he had to live out any consequences for his actions. Probably the worst was maybe people didn't want to work with him anymore, and it was a loss of income to some extent. So just crazy. Just crazy. So what a great write-up there, I think, from Reason. Again, that was from 2007. It's linked in the description if you want to go and revisit that and look at any of the individual cases. I don't want to make this stream too long because I've got to get to prepping some food, you know? It's always good when you read about crazy stuff like this. You got to balance it with a little bit of enjoyment and appreciation for life. But some crazy stuff we read. I mean, this all started with the news coverage yesterday of the Duncan story, where there's video and the victim's family members are saying, we want the public to see the video. We want people to know the truth. This sealed video where West, with this complex where he's more reliable than Jesus Christ, is just slamming and dragging dentition impressions all over a victim's body after the fact to make sure a conviction can be scored. And the man that was convicted is on death row because of it. When, if you ask me, maybe negligent homicide was right. Maybe he shouldn't have left the baby unattended. That was initially what prosecutors charged him with until West comes along and, there's all this buffoonery going on with this video that the jury wasn't able to see at trial. Maybe that would have been the right thing to charge him with. Maybe he should have been convicted for that. That seems a lot more appropriate than what happened to Duncan. And if he was convicted of negligent homicide, this was his trial was back in the late 90s. He'd be a free man today, I'm sure. I doubt his sentence would take him all the way through to 2025. And yet, even though a judge has exonerated him of the murder and rape for which he was convicted, prosecution wants to appeal that and retry him. So his freedom is still on the line. And again, that's only one of a handful of the cases of people like Hayne and West have been involved in that are being revisited. How long have they been hiding all of this? And I mean, that's the hard part, we're still hearing things like, and forget what seems like intentional fraudulent work. I'm sure there are people that have prosecutors, examiners, that relied on things like shaken baby syndrome and dental bite mark analysis in their work. They relied on it without doing anything wrong on purpose, but they believed in the science and they relied on that. And there's cases that with those things that helped contribute to a conviction that the people are still convicted. Some are still behind bars, some are still on death row. And that's based on a science that's no longer acceptable. And then you've got all these other cases involving foul play, where you had people trying to call it out decades ago already, and they said, you know what, let's get a petition together and get rid of this person that's calling for standard operating procedures. We don't want to take exams. We walk out of exams. It's just crazy. And we had a quote. It was from the Justice Diaz Jr. in the case with the 13-year-old. He wrote in his dissenting opinion, he advocated for taking the death penalty off the table because this is how easy it can be to condemn someone to death who might actually be innocent. So again, I think you guys, if you've seen some of my stuff a long time ago, especially on Marcellus Williams, I tell the story. When I was younger, I thought, if you're in jail, you did the thing. If you're in prison, you did the thing. When I was a kid, I didn't really understand how people could get it so wrong and get it wrong so often. Then you learn. Then you start to see the things, and I can't ever, religious or not, I don't think I don't think it's okay to trust the government to get it right in condemning someone to death. Maybe there are people based on the standards that, do deserve the death penalty for what they did, but how can we have confidence in the government's ability to prove that that's the person that actually did this thing that they're being accused of? So that's my philosophical stance on why I am opposed to the death penalty. And when I was like 13 years old, I wasn't thinking anything of that. I was just like, oh, well, they did a bad thing. Of course, it makes sense that they'd want to just sentence him to death, or her. But I don't think of things that way anymore. So with that being said, you guys, that was a lot of depressing topics here on a holiday. I hope people get to enjoy today, even if you are, not in the United States. There's still, freedom means a lot of things. And I hope everybody gets to cherish our time on the outside. Hang out with some family members. I'm in Florida. I know it's hot across the entire United States, I think. I think it's summer weather everywhere. Hope people get to go out, and if you're going to grill, if you're going to catch some fireworks, I hope everybody has a great time. If you're somewhere else where you're not celebrating 4th of July, hope you're just having a good one and get to do something, go outside, enjoy life. Remember that not everything is all bad. And also, Peter Ortiz says, "Why did you do it, Kat?" No, I didn't. I am innocent. I am innocent. I do hope if I'm ever in legal trouble, you guys cover my case. You guys cover my case for me. Oh my goodness. Heck yeah, summer here in the DMV. And even when I lived in New York, 4th of July would be sticky, sweaty, hot. Biff friends, enjoy. Enjoy. Happy 4th. Happy Friday. It's also Friday. Yeah, if you're not celebrating the 4th, celebrate Friday. Everybody, I think it's Friday everywhere except some parts of the world who are past midnight. In that case, enjoy your Saturday. YP Come Chic says, "Happy 4th, everyone. Make it a safe and great day." I think we'll end on that note, you guys. Thanks for hanging out. Thanks for caring about issues like this. Thanks for dealing with my rants. And see you next time something makes me start up one of these streams. You guys have a good one. Take care.